extensive agenda, so we'll get going. We'll start out with the chair's bill, House Bill 941. This is a bill where we had an extensive private hearing last Friday. Recall that, and there have been media reports on it, recall that under Georgia law currently, where there is a police shooting or a fatality, Georgia law enforcement enjoys a special privilege that is not like any other in the country. The bottom line being that the officer in that situation has the opportunity to be in the grand jury room, to hear all the testimony that's given, everything, the entire time, and then at the very end can go ahead and get up in the grand jury room having heard everything and make a statement and then not be subject to cross-examination. That model has lent itself to the possibility of manipulation by the officer in that situation. We're not making the assertion that that has happened. The DAs will tell you that has happened. The law enforcement officers will tell you that that doesn't happen. I think the reality is that the truth is probably somewhere in the middle, as it usually is in a situation like this. So what this bill does, in essence, is to, in reality, is to dial back that privilege to a certain degree. The police officer would still have the ability to appear in front of the grand jury. However, if they did appear in front of the grand jury, then they would be able to appear like any other witness, like any other individual in that situation. They would come in, give their statement, and then be subject to cross-examination like any other witness who would appear in front of the grand jury. And in this way, lends itself to I don't want to say a more level playing field, but it's more of a mainstream practice as opposed to what we have now in our grand jury, in this limited circumstance where you have police shooting and either a fatality or a serious injury occurs. The bill also increases transparency of the process. There are mandates for court reporting, so there's a clear public record as to what happened and when. If the civil grand jury makes the determination that no, there's no reason for the DA to go ahead and pursue a criminal indictment, that there's a written record, for the public to ultimately see as to what decision they made and why they made it. There have been some questions. We had, of course, the public hearing again this past Friday. Was pretty extensive, and it was very informative, and it was a good vetting of the issue. But there was a question or a statement that was made about what is the net effect of what we're doing in the grand jury system, and someone made the I want to say the allegation, but the statement that we were somehow eroding the grand jury process. And, that alarmed me because that certainly is not what we're doing in this bill. It's certainly not the intent of this bill, but we all know, whether we're seasoned veterans or newcomers, that sometimes legislation has the law of unintended consequences kick in. So I had a dialogue with our counsel, our legislative counsel, and if she could pull the mic toward her right now. And I think it's important that we say this out loud and that people understand it. And I asked our legislative counsel, Jill Travis, is there anything in the bill as it is right now that erodes the power of the grand jury, either in a civil context or in a criminal context, to do what it needs to do in its purview?
I would say that there is not anything that you've done in your bill that erodes what they can do. You haven't touched on what they can do in the civil or criminal context. The civil context is controlled by 151271C, which allows them to subpoena witnesses and all that. And you haven't changed anything in any manner in that regard. With respect to the criminal context, there's current law that provides for the prosecutor's ability to subpoena witnesses in whatever manner he deems or she deems appropriate to process the proceedings in a grand jury to get the witnesses there. There are not the same protections afforded to the defendant in a grand jury proceeding, but you haven't changed anything in current law in your bill in that regard. That is just current law. Okay.
Is there anything in the bill that you see as counsel of the committee that touches or erodes or amends anything having to do with the statute of limitations for murder or anything else?
No.
Okay. And I think it's important to get that out there because I think there's a little bit of misinformation that's gone on. We have right now in this current state of the law a very heightened privilege for law enforcement. This bill dials that back. It doesn't dial it back to where police officers are treated just like any other citizen in the code, because the thinking is that police officers in this narrow situation where they are discharging their weapon and a fatality or serious injury is occurring, they're not like every other citizen. They're agents of the state, and I think it's the sense of the General Assembly that they should have the ability, if they would like to go ahead and to tell their story in front of the grand jury. They cannot compel to do so. I heard an argument that, the grand jury can compel anyone. The grand jury can compel anyone by subpoena to go ahead and be in the grand jury room, but they can't be compelled to testify against themselves. They invoke their right under the Fifth Amendment, and then there's no testimony whatsoever. So that bit of, I think, unintended misinformation may be out there, and I think it's important to say that out loud before the chair goes to a motion. Again, there are heightened transparency requirements in the bill. That's to go ahead and give the public a very clear roadmap as to what the decision was on a particular shooting, frankly, why it occurred, and why it did not occur. I just feel the necessity to go ahead and make sure that's clear, and having questioned counsel, and I appreciate her indulgence in doing that, because I think it's important for members of the committee who may have a question about that, and the public at large, to hear that, not from me, not from members of the committee, but from the lawyer to the committee. So with that, having had the public hearing on Friday, I'd ask the committee to work its will. And what's the pleasure of the committee on House Bill 941? Excuse me, sir. We had our public hearing on Friday. Not today. Excuse me. We're in the middle of a committee room. If you have an issue you'd like to discuss, I'm more than happy to do that outside the committee room. More than happy to do that. Not today, and not on this calendar. No. Thank you very much. What is the pleasure of the committee? Ms. Ballinger.
Mr. Chairman, I would like to make a motion to pass.
Ms. Ballinger moves due pass of House Bill 941 by substitute. LC 296931 ERS. Is there a second? Second by Mr. Strickland. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentlelady's motion signify by saying aye. Opposed? The ayes have it. The motion is adopted. Thank you, members of the committee. Let me call Chairman Powell, Chairman Alan Powell. Chairman Powell has two bills on the calendar, House Bill 948 and House Bill 949. We can take that however you want to. I'll leave it to you. Just pull the mic if you would. 948.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee. Bringing to you this bill, and this comes from the Community Supervision Department. This is it's a quite simple bill, but the general background is that we have Georgia's a member of the Interstate Commission on Adult Supervision. In the state of Georgia and the other 50 states and 3 territories, if you're a probationer or a parolee, you can transfer out of the state in which you were convicted to the state of your domicile. In a lot of cases this works quite well, but at some point these offenders have an opportunity. They have to be remanded back to the state if they've broken other laws. There's been a fee for years of $25 for an application fee for these offenders, and we're recommending that it go to $100 to offset some of the cost that it's costing the state. On any given year, we've had over 14,000 offenders transferred out or within and out of Georgia. The cost of an 800 yearly average of retaking of these inmates, there's a cost involved into that, and this would quite naturally, going from $25 to $100, would go into the state coffers and help to offset the cost.
A straightforward proposition. Any questions for the author? 948's in your folder. It's LC 410688. Any questions for the author? Seeing none, what's the pleasure of the committee? Mr. Coomer moves due pass of House Bill 948, LC 410688. Second by Mr. Hightower. Are there any amendments? Ms. Ballinger? Oh, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it. The motion is adopted.
Thank you, Mr. Chairman.
You have House Bill 949.
All right. Thank you again, Mr. Chairman. Ladies and gentlemen of the committee, last year the General Assembly passed a bill that was done for ethics in government. Prior to that time, there'd been an awful lot of publicity about local governments and local elected officials that were using P cards, credit cards, and other type instruments, and they were using these to make purchases for their personal behalf. Some of this became quite embarrassing in the press, and it was dealt with a lot of the local governments, certainly not state government, but with the local governments. Last year we passed the P-Card Credit Card Act that said that that members of GAA, your municipalities, and your county governments had to enact a policy that all the employees that adhered to that basically said that once the policies were adopted that they could not use these P-cards or credit cards for personal use. Something that was, pretty well adopted. Haven't heard anything negative about that proposition. Since last summer, when the bill was signed, there was some other problems that arose. As you know as we all well know, we have constitutionally elected officers who feel at some points that they're not subservient to the local county commissions. And what we've done, a lot of them did not think it was right that they needed to sign a statement to the local government if they were running their own purchases. And what we've done to hem this up, we've brought forth a bill in conjunction with the Sheriff's Association and others that said that if you're a constitutional officer as described in this bill, and if you're doing purchases on your own and you don't wish to go through that county commission, then you as that elected official, you would develop those same policies based on the use of P cards and credit cards, and it would be published, your employees would know it, and you'd fall under the same category as an elected official. Secondary way of just hemming it up.
So just to be clear, it would apply that the policy would apply to sheriffs, tax commissioners, and
probate judges, tax commissioners, constitutionally elected officials.
Great.
If they don't wish to work with the county commission through their purchasing and to adopt and to sign an adopted policy that the county commissions have set forth,
okay,
then if they're going to do business on their own, then they've got to adopt that policy. It's got to be publicized, has to be recognized by them and their employees that they're under the same rules.
Okay. Questions for the author? Any questions for the author, members of the committee? Seeing none, counsel, did you have a question or an issue on the approach taken by the drafting council?
Well, I just found it difficult to follow the citations of the Constitution and wondered if it would be better to just put in the actual names of the individuals, which would be the clerk of superior court, the judge of the probate court, the sheriff, the tax receiver, the tax collector, and the tax commissioner, as opposed to sending the reader to the Constitution. Certainly, it's the prerogative of the committee and the author to do it as they see fit. I don't imagine that the Constitution is going to get amended to add other people to it. I just found it, for me, difficult to go back and forth between the Constitution.
What's the ordinary custom and practice in drafting as it relates to something like that? When you make that reference? Okay, fair enough.
Since I'm not an attorney and I may be the only member of the General Assembly that fully acknowledges he's not, I am at the will of the drafting council.
It's all part of the recovery process. Yeah.
Exactly right. Exactly.
Mr. Coomer.
Does this provision apply to district attorneys?
District attorneys are state. They're not constitutionally elected by the counties. They're state officials.
Is there a similar provision for district attorneys? Do we know?
I'm only guessing that the DA's council, that they probably regulate them. I mean, I can't tell you.
Okay.
But I can almost assure you with a certainty that if we start seeing news reports where DAs and any other state official is using their P cards or credit cards or whatever to take vacations, then I'm almost certain that we'll have some auditing procedures into place to hem that hole up too.
Thank you.
Welcome to Chairman Willard.
Thank you. May I just follow up on that? The question was, we had, I know in the press, something deal with one of the DAs in a local county having a P card, using it on trips, questioning about whether it was proper expenditures, and the county was not able to get the information because he claimed that he was not subject to their reviews. Just point of information about that.
Well, that may be so, but those same county commissioners, if they asked a question to a DA, just like a judge, their supplements could be in order if they don't answer questions.
Real battle to get into that.
And good luck to that.
Any further questions for the author? Seeing none, what's the pleasure of the committee? Mr. Coomer moves due pass of House Bill 949 LC 287916ER. Is there a second? Second by Ms. Ballinger. Are there any amendments? Seeing none, any further discussion? Mr. Coomer.
I would like to offer an amendment.
Sure.
I'd like to, following council's recommendation, to strike the reference to the constitutional provision and inserting instead those listed offices.
I think we can go ahead and just frame the amendment in terms of structural for council to go ahead and just strike the appropriate, if the amendment were to be successful, to strike the appropriate language and to list it out office by office as she enunciated before. Does the author have strong feelings about that?
I do not, as long as it works.
I hear you loud and clear. Any further discussion on the amendment? Any further discussion on the Coomer amendment? Is there objection to the amendment? Is there objection to the amendment? Seeing none, again, the amendment will be framed in terms of wherever that reference occurs within the bill, and we'll just have that as a general instruction to council. Any objection to the amendment? Seeing none, the amendment is adopted. Any further amendments? Seeing none, on the underlying motion of due pass by substitute of House as amended House Bill 949 LC 287916ER, all those in favor say aye. Opposed? The ayes have it. The motion is adopted.
Mr. Chairman,
Thank you, Chairman
it's been
Powell.
a great pleasure appearing in front of your committee, and if I can reciprocate it with the Committee on Public Safety, whether the bill is posted or at the discretion of the chair, I'll be more than glad to accommodate.
I'm not sure Chairman, I'm not sure I'm prepared to deal with that level of controversy.
I understand.
But thank you. Let me call Mr. Efstration's House Bill 770. Mr. Efstration, I'm going to
Subcommittee. Setzler.
Mr. Efstration.
Thank you, Mr. Chairman. I present to the committee a committee substitute to House Bill 770. This is LC 296908S. Mr. Chairman, this was passed or received a due pass recommendation from Chairman Setzler's subcommittee of this committee. Mr. Chairman, we have present today GBI Director Vernon Keenan, Attorney General Sam Owens in support of the legislation. These officials testified in support of the bill at subcommittee, as well as many other advocates that are present. Mr. Chairman, the bill has two primary purposes. First of all, it allows for law enforcement to conduct undercover investigations to build cases concerning human trafficking investigations. It does this while preserving existing defenses. There's no erosion to existing defenses, explicitly providing for a specific defense in the language. The second objective is to include victims with developmental disabilities within the victim class that is characterized in the statute. This would provide for charges to be brought and cases to be made in circumstances where traffickers or individuals that are working in concert with traffickers that would otherwise fit under the statute may be prosecuted for victimizing victims with developmental disabilities. And Director Keenan testified that GBI investigations have shown that these victims are being specifically targeted because the traffickers believe that the victims will be unable to testify when the case goes to trial. We really have very serious crimes that we're discussing here, and we're asking that it be included in the human trafficking statute so that these offenses might be prosecuted. Final item, Mr. Chairman. The definition of sexual servitude has two alternative definitions under existing code right now. Subsection A and B, as the committee will see here in the bill. And in subcommittee, upon examination of the B definition and hearing from prosecutors that actually prosecute these cases, B was believed to be overly broad and is not used in prosecution. So it's the recommendation of the subcommittee that B be struck from the definition, that only the definition under A continue. And so that is included in this legislation. Law enforcement that I've consulted with is okay with that change, and therefore we are asking that the committee give a do pass recommendation.
I know this came out of Chairman Setzler's subcommittee, but he's not here right now to give a subcommittee report. Any questions from members of the committee on House Bill 770? And I assume in subcommittee there was testimony.
Yes, sir. There was testimony
on both sides,
and we had. That's correct, Mr. Chairman. I'm happy to cover that if you'd like. There were two hearings. The only real issue of controversy was whether or not a knowing element was necessary for the crimes perpetrated against victims with developmental disabilities. And my response, and I believe the policy position selected by the committee, was that we do not do that under any other area of the law. For victim classes that are specifically provided in statute, it is not an element for the prosecutor to prove beyond a reasonable doubt that the perpetrator knew of the classification at the time. And that's for age, be it young or elderly. That's for classification as law enforcement. There's a variety of other areas in the code where that requirement is not to be put in place. And I believe my statement to the subcommittee was, if the General Assembly wants to change that policy, then very well bring legislation for consideration. But this is simply to extend the victim class to developmental disabilities under the existing standards that we have.
Questions for the author from the committee? Any questions for the author? Seeing none, what's the pleasure of the committee on House Bill 770?
Move to pass House Bill 770 by substitute LC 296908S.
Is there a second? Second by Mr. Reeves. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it. The motion is adopted. Thank you, Mr. F.
Thank you, Mr. Chairman.
Mr. Raffensperger, we're going to continue your the consideration of your bill as a carryover from last meeting on House Bill 790. Welcome back.
Thank you.
Can you give us, I know you don't want to reinvent the wheel, but we obviously, the committee had an issue
Yes, Mr.
in the last meeting. I think it would be helpful if you were to give us the brief synopsis of the issue and then what action you've taken in the substitute to address it.
Okay, thank you, Mr. Chairman and ladies and gentlemen of the committee. In the interest of time, I'll just go over the two changes that were suggested from your two members. And the first one was what we did on page 2 on line 38, actually starting on 39 and 40-41. For the first offense, it was changed to a misdemeanor of high and aggravated nature, and then upon conviction of a second or subsequent violation of subsection B of this code, and that was as recommended by few folks on the committee. And then in the original substitute bill that we had, which you probably wouldn't have in front of you, but the original reading, we had a line 38 and 39, which were stricken from two of the members. They thought it was overly broad, and in discussion with legislative counsel, she concurred that it did appear to be overly broad. So any other incident that would reasonably elicit an immediate heightened response by law enforcement or emergency services was taken out of what you have before you today. And those were the two, I felt, directives or that were of concern to the committee last time. So hopefully, Mr. Chairman, that I've cleaned this up, and I would ask for your favorable consideration.
Thank you for your work on it. Let me I know Representative Hightower, we had a dialogue involving him on one or more of the issues that the bill had as introduced. So let me recognize him for his comments.
Thank you, Mr. Chairman. Representative Raffensperger, thank you for taking our concerns and addressing them here. Mr. Chairman, I support the amendments that the substitute that he brings before us today. He had concerns both from myself and Representative Trammell, and it looks as though he addressed both those concerns. I think he has a good bill. Thank you.
Thank you for the comments, and thank you for working within the process to cure concerns. And it just takes time, and a little bit of will, and you can really address concerns and strike consensus.
I did hear that Chairman Powell said he would be the only one that would admit he's not an attorney. Well, I'm an engineer, so I have to admit and understand that the Learning Committee probably has much better expertise in these areas than I would.
Not necessarily. And I'm the first one to admit it. Not necessarily. But thank you. What's the pleasure of the committee on any questions for the author on the revised substitute to HB 790, which is LC 296946S? Any questions from members of the committee on the new substitute? Seeing none, what's the pleasure of the committee?
Chairman, I move do pass LC 296946S.
Is there a second? Mr. Hightower moves due pass of HB 790 by substitute LC 296946S. Second by Mr. Trammell. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted. Thank you.
Mr. Chairman, thank you for your time. Committee, thank you.
Thank you. Make sure you don't forget to go to rules and fill out the form.
I'll do that right now, sir.
Okay. Ms. Chandler, you're here on House Bill 744. Come on up. Sure, that's fine.
With me, and there's a gentleman from Page out here. May I tell him to
Sure.
come in?
Yeah, that's no problem.
There was standing room only. Excuse me, I'm sorry, Chief. Thank you, Chairman Golick, and I also thank Chairman Setzler and the members of the subcommittee that heard this bill last week, and I heard what you said, and I don't have a copy of the substitute, but I know what's in it. The substitute that came out of the subcommittee. I think I know what that was.
Let me ask you to confirm which substitute you'd like to work off of.
Well, I need to know. I don't know a number. Oh, okay. I think no. Let me first mention the other substitute.
Okay.
And I don't know the number. The one I have in front of me is LC 336496S.
And that's what came out of subcommittee?
No.
Oh, okay.
That's what I added as a sub to the sub. I don't know
Okay.
if there's such a thing. Remember, I'm not an attorney, so
No,
you
it's all right. I mean,
bear with me on that.
if Ms. Chandler, if you'd like us to go ahead and, I think we do have to cover, and unfortunately Chairman Setzler's not here, we do have to cover, and I may lean on Mr. Spahas to do that if he can recall, and if he cannot, that's fine, or a member of that subcommittee as well,
Or I can do
to
that.
talk about the distinctions so that members have a clear roadmap as to what the policy differences would be. However that can work is fine. So we can lean on Mr. Spahas to tell us about the distinctions between the substitute that came out of the subcommittee and then what I'll call the Chandler substitute that you're offering here or asking the committee to talk to today, or to consider today.
If I remember correctly, what came out of the subcommittee involved, you got two real issues: whether or not you're willing to come out from under the concepts of supervision and authority over a student in a school environment and take that away and say, if you're a school employee, then we're going to hold you accountable as far as not having these kinds of contacts with a student. And then if we're going to do that, whether or not it's going to be a misdemeanor of a high and aggravated nature or a felony like it is in the other two provisions. So I believe the original substitute that came out of subcommittee shifted it to a misdemeanor. Is that, if that's okay? Well, then Jill's remembering it better than I.
I don't.
All right. I must say, I'm a little disappointed that we don't at least have the sub that we did in committee, because on committee we spent a great deal of time on this bill. And the problem that I'm having here is not that we have a sub to a sub. That's fine. This is your bill, Representative Chandler, and so if you want to do that, it's completely fine. But this seems to me, with all due respect, a way to kind of avert the committee process. In the subcommittee, we spent a great deal of time working on this exact language just to have it brought before full committee exactly the way it was before we made all of our changes in subcommittee, which is fine, but we at least need to have the language how we had it. And what we did in the subcommittee...
Well, let me suggest this. Mr. Hightower's point is well taken. I think I didn't realize that the subcommittee substitute wasn't in the file. I think it's important for the membership to have both in front of them so they can compare and contrast and then make an informed decision about what direction they want to go in.
Okay.
So allow me to suspend consideration of your bill temporarily while we go find the substitute that came out of subcommittee, make copies, circulate it to make sure everybody has it, and then we'll continue consideration at that time.
I think, Mr. Chairman, that the only thing that came out of the committee was it was just adding one word and striking what I originally had in.
I can tell you, Mr. Chairman, what it was, if you'd like.
Sure.
And I can give you the background, because if we're going to do it this way, which I'm fine, but if we're going to do it this way, then I think we need to rehash what we did in subcommittee, because now we're trying to undo with a substitute the whole debate we took for over an hour, I believe, in subcommittee. So if we're going to start here, then we need to start with an open dialogue again.
I think I'd be more comfortable if we had both documents in front of the members. I think that'd just be the
understand.
cleanest approach to do it, and that way they've got it right in front of them and so forth, and that's not hard to do. We just have to find it. It's in the file somewhere.
Okay.
And we'll make copies of it. What we can do is shift over into another bill and then come back if that's all right. I'm sorry for the delay, but I think
Sure.
that's the right approach.
That will be fine.
Okay.
May I just say something to Mr.
Sure.
Representative Hightower?
Sure.
The only reason I even thought about a sub to a sub is because you mentioned it.
You can. No, I'm fine with
So
that.
I wouldn't have known
We
I
just
could.
need what we come out of
Yeah,
committee.
and you certainly can propose it,
I didn't realize they
and
didn't have it either.
we certainly would allow for that. We just want to make sure that the members know, pursuant to the process, what the contrast was between the two.
usually have that other copy here.
I do understand that you need it.
Okay. All right, so we'll suspend consideration of House Bill 744 temporarily. Let's, and what we'll do is we'll shift over. We'll shift over to House Bill 205 and Chairman Rice. No. That's the
Well, thank you, Mr. Chairman, and members of the committee. I appreciate the opportunity to bring House Bill 205 to you today. This is the result of 4 or 5 years worth of with effort in terms of looking at the DUI issue, seeing if there's a better way to work our way through this, hopefully to save lives and to hopefully cut down on the number of accidents in terms of saving dollars, as well as a great deal of stress on the families. I want to thank Ms. Travis was here a second ago. Okay. and Jenna Doley for all their help. And certainly I want to thank Representative Hightower for his help on this, as well as others on this committee. I think I've seen most of your faces before in subcommittees, so there's probably not an awful lot new to talk about. But what you do have in front of you today are two things that I've included in your folders that will hopefully make this a little bit easier to explain in terms of what how this is going. If you take a look at this particular chart, that basically is the comparison of the of what the process is now in terms of handling DUIs as opposed to the what's proposed in House Bill 205. I think it's important to note that that House Bill 205 really presents an opportunity to get people in a driving circumstance where they will not have the capability to drink. In every circumstance that we can find, there's an opportunity through various limited driving permit opportunities or just the opportunity after arrest to drive and drive without any impediment in terms of any kind of limited in terms of any IID. And basically, the bill's divided into two parts, and I'll just cover briefly a couple of them because you've got the explanation in front of you in terms of what each line does. And I don't think it's necessary to go through line by line unless you want to do that. But let me just say, in the overall, Section 1 basically contains the current DUI ALS law. Basically, what's happened is we've removed any reference to the IID. The ignition interlock device from Section 1, moved it to Section 2, and then we've included new terms that deal with how the process will be handled according to this particular chart. And so that's all found in the succeeding sections, primarily in Section 1.6, and I'll cover that in some brief detail if you want to do that. Let me just go back to the chart again here. The chart. Basically, if you start at the top, the option for HB 205 is indicated as a refusal of the test, which is where the controversy on this issue is going to arise today. And it's a good discussion to have in terms of public policy and whether or not the implied consent issue and the ability to get convictions is more important than keeping people off the road while they await their trial. I mean, that's basically what the issue is. And so you see a couple lines there. The one I'd point you to, though, is that red hatch line that says equals driving. And in the cases that you can look at, in the red hatch line in option number 1, that's driving, but that's driving with an ignition interlock device on. If you in fact take the test, you'll have that on for 4 months. At which time, current law, you can get a license reinstated. If you do not, if you refuse, you're going to have that device on for 12 months, and that's basically the substance of it. What happens here, from a procedure standpoint, is that after arrest, you've got 30 days to file for an ALS hearing. You got a 45-day driving permit, which was requested by the department to give them some time to process that. And then if you choose the IID route, you got to prove to the department that there is an IID on your car, and you waive the ALS hearing at the same time. It's gone, which should save time, money, and a lot of consternation on the part of the officers. I think the colonel would agree with that, as he has in the past. At that point in time, you either have it on for 4 months or you have it on for 12 months, and you go to court. And if in fact you're found innocent, you get it. It's taken off, and there's no harm, no foul, no reinstatement fee. So that's the option that we're proposing here. The other options you can see in terms of refusal to take the test or take the test under current law, you're going to go to the ALS hearing in the refusal in point number 2. The officer and the person who's effectively the offender in this case, or the one who was arrested, is, and this is where the consternation I think comes in, is generally confronted with the option as to whether to agree and get their license back, that they plead the case and get their license back and drive right away, or they don't. If they plead, they get their suspension withdrawn. That's the way the thing works currently, apparently. And then they go wait 4 to 12 months, and they get a court hearing, and then you've got the court hearing. 4 months after that, they can get full license reinstatement again. So the point here is the red hatched line. The red hatched line says that they're driving during this period of time. They're driving. And there's no encumbrance on them in terms of being able to drive drunk as they were before or not, except their own recognizance, basically. And the same thing's basically true with point number 3, which is that when they take the test. They can apply for that ALS hearing if they want to. But generally what happens is if the defendant comes to this and does not agree to take a plea, the officer suspends the license because there's no agreement, and the defendant gets a 30-day permit through DDS, and off he goes again to continue to drive. So, the question is, from a policy standpoint, is there anything to the administrative license suspension process that's going to control the behavior that we're talking about? And I don't see any at this particular point in time except the threats that come with this. So we would prefer that the person accused has an option to drive, since we believe he'll drive anywhere, anyway, even with a limited driving permit that has 5 or 6 different opportunities for him to drive to the doctor, take his kid to school, all those types of things, which are, I don't call that very limited. To tell you the truth, drive to work, you can do all these things. We want to do these things. We don't want to lose their job. Right? They won't be able to pay for their attorney costs, or they won't be able to pay the court fees on these things. So we just think this is a better alternative. Mr. Chairman, I would be happy to go through this line by line, if you want to go through it line by line. But other than that, I'd say if you want to ask questions, that would be fine at this point in time, too, whichever you prefer to do.
The broad brush of it is that it will allow the option for an individual of the interlock device,
or ALS,
or to go the ALS route,
or the current route, right?
And it allows that to the driver as a matter of right, or this occurs and they have the choice.
They have the choice.
They can exercise it or not exercise.
That's exactly right.
Okay. Let's get a report from the subcommittee chair, Mr. Hightower, for his perspective of what came out of subcommittee and why.
Thank you, Mr. Chairman. What we have in 205 currently, what sits before you today, was a collective effort to try to find a way to alleviate ALS pressures, because we had gotten, especially from the colonel, said that a lot of the officers were not particularly fond of the ALS process. We were also trying to find a way to implement new policies and procedures for coming up with innovative ways for public safety. And we knew that there wasn't an appetite for any type of mandatory interlock device on a vehicle on a first. But there was an appetite for interlock devices on DUI cases. We just didn't want to mandate it. So what the committee came up with in trying to formulate a way to accommodate those concerns was tried to find a way to alleviate some of the ALS pressures so that officers did not have to attend, and then also find a way to implement further public safety by giving an option for intox devices on vehicles. And so what you have before you today, current law is completely the same. We don't change current law with this bill as it applies to the criminal side of DUI, and that was done purposefully because we were told by many folks if we start messing with that too much, then we're going to find ourselves in a lot of litigation appeal on how we're affecting the criminal side. So what we came up with was an alternative to try to address it on the ALS side, the administrative license suspension side, and try to come up with addressing the concerns, the ALS overload, and also the public safety. So what we came up with is a person can go through the regular DUI process right now. They can choose not to exercise the option that 205 has before them, and nothing changes. They go through the current process. We're not changing anything. Or they can choose the new option that 205 proposes. And here's what 205 proposes. If at the ALS hearing you opt into having an intox device in your car, you can then waive your attendance at the ALS hearing, which means you don't have to attend and the officer doesn't have to attend. But in doing that, you're opting into having an intox device on your car, which is the current law not required. Those people just get to drive. If you refuse the state test, then that intox device has to stay on your car for 12 months. If you take the state test on the day of your arrest and you choose this option, then the intox device has to stay on your car for 4 months. Now, a lot of the pushback that we've had since that hearing has come from PAC and their solicitors here, and their issue is they're saying that this could possibly motivate refusals. Because current law, if you refuse to take the state test, at the ALS hearing, the officer can say, if you don't agree to plea, then we can suspend your license for a year. And so they have that hammer of suspending your license for a full year, current law, right? But by doing 205, they're saying the incentive comes, in other words, the reason I think their argument is, and Chuck, I'm not going to try to misquote you guys, but I'm trying to get y'all's side of things to be fair. Their side of things is that by allowing someone to choose an intox device for 12 months is incentivizing someone to refuse. And that's where we kind of didn't match up. And as Chairman Rice said, I think that where the committee is going to have to find their feet is, do you view an intox device as a deterrent, and does it promote public safety to the level that you want? Because under current law, when someone refuses the state test, that person 90% of the time stays driving the entire time. They usually don't lose that license. Because ALS, they work out a deal with the officer and they agree to plea, and they usually stay driving. If they choose this option, if they refuse, that person would now have an intox device in their car for a full 12 months. Now, one thing that's not in this bill, but I would propose, it is a slight change. We did say up until they came into a court date. The way that I think it would need to work, though, Mr. Chairman, is that if they came to their court date and if convicted, let's say they get convicted within 8 months, I think that 12 months needs to keep going. I think that goes unsaid, but I think that 12 months, they need to serve the full 12 months. And I think that would work currently the way we have it. But essentially, that's what we did. We made a new alternative path for someone to opt in. And if they opt in, they're going to have that intox device. Sorry if that was long-winded.
No, I think that was an excellent summary of just how we got to where we are right now. We'll open to questions from the committee. Ms. Randall, is that you? Okay.
Answered one of my questions. So I'm a little on the fence here, because if the prosecuting attorney's counsel feels as if it's going to increase the refusals, what's the midway? What can we do in between that? I mean, honestly, I'd like for everybody that gets a DUI to have one of these devices on their car on the first one. But if this is what we're dealing with, what can we do? Was anything suggested from the council?
Sure. Well,
in lieu?
Is that for the author or for Ms. Tritow? Or
I don't know.
Anybody wants to, I think. I'll comment on it, and then Representative Hightower can comment on it. It would be great if you'd allow that.
Sure.
My view of it is, if there is a refusal, we provide for that if they've gone this direction. If they've taken the option, they are going to get that intellect device for 12 months. To me, that's a best case scenario in terms of even determining what the behavior will be of that particular individual over a period of time. Obviously, with that thing on, they're not going to drive drunk.
Right.
And so that's the objective of the whole administrative license suspension thing, right? Which to me doesn't seem to be working unless there's a conviction out of this that says, I'm going to allow you to drive if you plead. And that's, and that's how it effectively works. So my guess is that you probably drive the number of interlock devices on a refusal basis. In other words, more people would have interlock devices. Right. I would think. I mean, that would be my supposition.
So that's why I'm confused. So what if it causes more refusals and they get interlocks? Is that bad?
And again, that's where each committee member is going to have to deem that for themselves, because my side of things is no, because now we have an interlock device on someone that otherwise would never have to have one. So, right. And it goes to accomplish what I think your concern was. You'd want to have it on any time. Well, if they choose this, they got one. But I was trying to be fair and give both sides. You asked if PAC had offered an alternative, and they did. PAC's alternative was to, and I think Chairman Reed or Representative Reeves may introduce this as an amendment. But their amendment, if I understand it correctly, will be that they don't want this to apply to refusals. They want it only to apply where someone took the state test. But if we do that, I don't think that Chairman Rice's bill is going to be effective to do anything, and here's why. Under current law, when someone takes the state test, mm-hmm. right, and they go to their ALS hearing, and at that ALS hearing, they don't work out a deal with the officer. In other words, they don't agree to plea, and so the officer says, well, I'm going to suspend your license. Well, under current law, what happens is that individual who took the state test, and this is only for those that took the state test, that person the very next day can go to Conyers and get a work permit and be driving within 24 hours. 30 days after that, if they've taken the risk reduction course, they can go back and get their full license back. So a person who took the test under current law, they can be driving with a full license within 30 days and with a permit within 24 hours. So why would that person, if they know that's an option, why would that person choose to have an intox device on their car for 4 months as an option? You see what I'm saying?
Right.
But so the only one that, and that was their alternative, and I believe that's going to be the amendment. I may be wrong, but I think that's it. But that doesn't really have any teeth, because why would you choose that? The one that really gets teeth to the matter is where we deal with refusal. Because if you refuse, you can lose your license for a full year, or you can opt in and put the intox device in your car for 12 months.
What's the difference in the financial obligation between the class and the interlock device?
Hey, Chairman Rice have to deal with that. I'm not sure what the cost of these intox devices are, to be honest.
There's an installation cost, there's a de-installation cost, and there's a monthly cost. And it ranges because it's not set by the state. It's a competitive marketplace. It can range, and I'll let Mr. Dallas comment on that, since he has represented that organization. If you will allow that, Mr. Chairman, for Mr. Dallas to comment on that.
Briefly, if you would.
$75 put in and take out, and about $2.50 a day for a period of time.
$2.50 per day.
That's for monitoring the device.
And I think the classes run about two. It's statutorily, isn't it? What's two?
275.
It's 2 something.
So the classes are not over 200.
Yeah.
Is that right?
Yeah. 225.
Any further questions for the author? What we basically had was a discussion on the amendment that's coming, so we're not going to do that twice, just so we make sure it's clear. But it's a good discussion, and I think that actually is the heart of the issue. I think, at the end of the day, this is a device that, the question is what will be the parameters of the option of using it? Is it going to be broader? Is it going to be narrower? And what are the public policy imperatives behind both of those priorities? And it's a good debate. Any further questions from members of the for the author from members of the committee?
Summary comment, Mr. Chairman.
Please.
If in fact the amendment that's proposed is what I think it is and what I've been told it is, and if that passes, then I'm not sure that this bill is worth your time to consider further. I mean, that's kind of my personal feeling on this.
Well, let me
I've
ask you
worked
that.
on this for 4 years.
Let me ask you that. I mean, and I'm not sitting here persuading or dissuading on that. I'm balls and strikes at this minute. If the option is exercised, but it's only if someone goes ahead and takes the test, I mean, is a practical matter just from a ease of process, lessening the likelihood that they might have a problem in their lives because of their ability to keep driving or not keep driving. I mean, as a practical matter, it seems to me there's only plus on it. It's only on the plus side, regardless of how broad the option is available. It's just a matter of degree. Obviously, you're going to have a broader usage if a refusal can go ahead and take advantage of that option. But just because they can't doesn't mean that there won't be a. And I'm looking at it from a public safety standpoint. Right. To me, that's the way I'm looking at it. Is there anything lost in the area of public safety, or is there a net gain?
Answer the question. I think as long as the current option exists, I think Representative Hightower is right. I don't think they would install an IID for the 4-month period that's proposed here. I think they'd go ahead and attempt to work through getting their license back as soon as possible, and they can do that, as Mr. Hightower aptly explained. So, the only way to do something about that would be to make the taking of the test in the current law more punitive, one way or another, to force that option onto the other side. I really don't see a way to do that easily, to tell you the truth. Or not even easily, maybe just it would not be good law, I don't think. This is already, as we know, complicated enough for people that to provide the option is, I think, a great opportunity. But it only really works if the refusals, I think, are included.
Okay. If there's an amendment offered, I'm going to, just for the author's sake and for members of the committee, if there is an amendment, I think the tradition, if it is a policy call, that I will go ahead and ask the author for his input on the amendment, which the committee will take in and take under advisement as they vote one way or the other. It's just to make sure we have a clear idea of the bill and the ramifications, and then of course the author's feeling as well. But ultimately, members, as they always do, will vote according to their conscience.
Well, look, it's been a long slog through this, and I thank you all for being attentive. And it's a complicated area of the law, and I don't envy your decision. But from a public policy standpoint, I hope we've offered you something that will really work to take drunk drivers off the road.
Members, thank you, Chairman Rice. And let me thank you publicly for your service here in the General Assembly. Chairman Rice has announced his retirement, and it's been a pleasure.
This is the reason I did that. It's a spill.
Huh? Well, hopefully we'll salvage something for going into retirement.
Yeah. Mag has some comments too. I think you might want to hear about the bill.
I think we're at the point where I think we know what the process is going to be. We're fully aware. We did get the packet from MAD, and I know we've all been contacted over the course of years, plural, by the advocacy groups on both, including the prosecutors, including MAD, including the interlock people. So, with all due respect, I appreciate the flexibility. Members, we're working off LC 296952 as in Sam of the substitute of House Bill 205. Chair will take a motion. Ms. Randall.
Thank you, Mr. Chair. I move that I move do pass substitute to HB 205.
Ms. Randall moves do pass of HB 205 by substitute LC 296952S. Is there a second? Second by Mr. Gravely. Are there any amendments? Mr. Reeves.
Thank you, Mr. Chairman. I have put a lot of thought into this bill. I was on the study committee that met this fall, and there's obviously been a lot of work, years of work, and a lot of passion that has gone into this, and probably nobody in the committee will ever know the time that Representative Hightower and I have debated these issues with each other. I think that as practitioners, he and I do probably the most DUI work of anybody on the committee, I think, and so it's probably odd for us to be in that position, but to be on different sides of this issue. I do believe in this concept. I do applaud what Chairman Rice has done, and I do think that it can serve the purpose of changing behavior, and I do think that it can solve one problem. And as a DUI practitioner, I certainly know how complicated and problematic our entire ALS process is. But my feeling, and it really dawned on me when we were sitting in the last meeting in the study committee, I was sitting right here and a light bulb went off in my head, and I think that while this may solve one problem, it's my deepest belief that it creates another problem, and it really goes down to the heart and kind of the cornerstone of DUI accountability. And there was a story in the Atlanta Journal-Constitution printed off in December, booze-related traffic fatalities on the rise in Georgia, and it just talks about some of the statistics, things that are going on, and makes me and all of us realize the significance of this problem. We talk a lot about heroin and pills nowadays, and we don't talk as much about DUI, but it's still a very serious issue, and people are killed every day by drunk drivers. And the concept of implied consent is truly the cornerstone of DUI accountability. I mean, it's the piece in the corner to me that brings accountability to DUI. And as you all know, applied consent is essentially your agreement with the state. If you drive your car on the roads, then you're agreeing that you're going to drive safe. And if an officer doesn't believe you are, you're agreeing that you're going to take the test and show whether you are or you're not. And so I think that by offering this option is a way to avoid the harshest of DUI penalties, and that's the suspended license. And I feel that we are incentivizing refusals. And so I want to be as clear as I can be. I do not disagree with any of the data and any of the concepts that Chairman Rice has brought forward, but I believe that creating this incentive for refusals is going to erode the concept of implied consent. And I think our policy statement then becomes that we're incentivizing for you to not hold up your end of the deal and take the implied consent test. And I think it could change DUI accountability. It may take years, but none of us have a crystal ball, and I could be wrong, but my amendment is urging us to take a half step with this and not to offer this incentive for refusals, but to offer it in other cases. And so I know that the committee has a copy. I've been scrambling around because I realized that that my amendment was to the prior version, the prior substitute. So everything's the same except for some lines have changed. Mr. Chairman, do you want me to walk through?
We're operating under with AM 390149. What I'd like you to do is to briefly summarize the effect of the amendment, and then I want to ask counsel if she's clear on the potential plug-in of the amendment into the underlying substitute.
And Mr. Chairman, Solicitor General Morgan can do it faster and more clearer than I can do it if he can possibly.
That's fine. Mr. Morgan, if you're comfortable.
Mr. Chairman, I appreciate the opportunity to speak. Thank you, Representative Reeves, and thanks everyone on the committee. We have had some spirited discussions in this, and I think from the misdemeanor DUI prosecutors across the state, we do believe that that the bill in its current form would incentivize refusals and would allow, if public safety is our priority, would allow for individuals to come to court quicker. They've refused the test, they've refused field sobrieties, they've refused everything. Once they know that this process is available, they will continue to drive until the day that we either dismiss their case, they file a speedy trial demand, and they're found not guilty, or it's a reduction to reckless, and then they get their full license back, and they're going to be driving within 2 to 3 months. But what Representative Reeves' bill would do is just take out the provision that allows for the interlock device on refusals. And let's take a look and see how effective it is. Let's take a step back. Let's do the half step. Because if the public policy of this state is that you're privileged to drive, there's going to be consequences if you take away the license for refusing to drive. Then I think we will incentivize the refusal process, and that will shift the problem from the ALS side to the criminal side, and we will have fewer convictions.
Thank you. For the summary, any questions for Representative Reeves or Mr. Morgan on the Reeves Amendment, AM 390149? Questions on the amendment, Mr. Strickland?
Thank you, Mr. Chairman. Mr. Morgan, you hit on this at the end, but I think the bigger issue here is what happens at trial now. Can you speak briefly about the challenge that you have of securing a conviction where there's no test that's been done versus where there has been a test?
I'll give you an example of a case I have right now. An individual who has been arrested for his 7th DUI. He would be eligible for an interlock under this bill because his prior conviction was more than 5 years ago. If you look at his history, it would be conviction for DUI, reduction to reckless, not guilty. Because he learned along the way that if I refuse the test, if I refuse the field sobriety evaluations, if I am simply on a roadblock, if I am simply have no manifestations of bad driving, if I put a sign on the window that says, I refuse to open my mouth to you and not speak, there is absolutely no evidence. So when that case comes to court, there's no evidence to prove a DUI, and we as prosecutors would have the duty to not prosecute that case as a DUI. That guy's going to come right back, and guess what? He's now a first again, so that when he gets back in his car with his license back, he's going to be a first all over again, and he's never going to be subject to a DUI. That's my concern, that we shifted, and I acknowledge the problem. I don't disagree with the author and Chairman Hightower. I don't disagree with that there is a problem over there, but we're just shifting the problem to the other side, and I don't think that's what the public policy of this state should be.
Mr. Coomer.
Just want to follow up on that last comment. You were talking about the 7-time person arrested 7 times for DUI, and doesn't it really cut the other way, though, that you would like to have this guy with an interlock device on his vehicle so that he can't drive that vehicle while he's intoxicated? I mean, he's been able to game the system all these ways. He's figured out his way around all the rules and figured out all the loopholes. So at least when it comes to driving his own vehicle, he can't drive his vehicle at least for the time that he's under the ALS suspension, even if he does get out of the ultimate criminal conviction. I mean, doesn't that kind of flip the argument on the other side?
It may, except when he gets another individual to blow into the machine, cranks the car, and never turns the car off, because he can drive drunk.
Well, that would be an argument against ever having interlock devices.
Absolutely, but if we're going to allow it,
that's not what we're discussing today.
But if we allow it, that is a possible consequence of what happens.
So you're just against interlock devices?
I'm against incentivizing by allowing people who refuse the test to have an interlock device.
Okay, thank you.
I mean, no, I'm not against interlock devices altogether.
Mr. Tremble.
Thank you, Mr. Chairman. I think Representative Coomer just asked a question, but my question is about that, as a public policy matter, is about the efficacy of the interlock device. If they work, it seems like we ought to do this. And if they don't work, we shouldn't. So what I'm asking for is your opinion about the efficacy of the device.
I think if you required a photograph of the individual who's blowing into the machine, if you required that every 15 to 20 minutes that they blow again, then I would much more support the concept. But as it stands, any individual can blow into that machine. We have no accountability to that. And once the car is started and they go to the bar and they leave the car running and they come back out intoxicated, there's no guarantee that they're not driving while intoxicated with that interlock device on their vehicle.
Any further questions for Mr. Reeves or Mr. Morgan on the Reeves amendment? Mr. Hightower.
Mr. Morgan, with all due respect there, and I know when you say that, sometimes you're starting off to not say something nice, but you can make that argument on anything. Every refusal, every suspension, anyone could always drive. You could drive with a suspended license. That's not really the debate here today. So I mean, you're kind of diverting the argument where it's not needed on that, because that argument could be made to any law. Anybody could break it. We're trying to see here, and Representative Reeves said from his seat that he is not objecting to the validity of this machine. He said he's not contesting the facts that were presented and that they do work.
Mm-hmm.
And so
I was responding to a question, Representative Hightower. I was responding to a question.
And I think the way that it needs to be broke down is exactly what Representative Trimble said. If these work, then this system that's proposed in 205 should work. And I assure you, I am not for incentivizing DUIs. Anybody who's been in these hearings long enough knows very well that I had a cousin run over by a drunk driver and killed. He was walking home doing the responsible thing, and a drunk driver ran over him. And he is no longer with us. So I promise I'm not here to incentivize bad behavior. But I know what happens in the real world, as do you. And on refusals right now, those people stay driving. They go to those ALS hearings, they make an agreement with the officer, and they stay driving.
Absolutely.
They drive the whole time.
Absolutely. I agree with that.
All I'm trying to do is make an alternative option.
Mm-hmm.
That if they don't follow the traditional path, it's still there. You still have that option. That path is still there. But on a refusal, if they make this option, we now have an intox device on a vehicle for 12 months that will otherwise never have one. And if we're going to say they work, as Representative Reed said, he's not going to contest the numbers that we've given that they work. If they work, then this does accomplish public safety. If they don't work, based on your argument, anyone can blow in it, they can non-crank the car, then we need to scrap this whole bill. So if they work or they don't.
All I'm saying is to take your point that an individual whose license has been suspended is going to find a way around the law. They're going to find a way around the law here too.
And that may be true. It may be true. But as legislators and as policymakers, we can't just say we're going to be defeated, so let's do nothing.
And I don't ask you to do that. I'd simply ask you to take into consideration that we're moving the problem from here to here, and ultimately, we're no safer because these people have gained the system and they've learned how to get around it.
Last word.
Where I think we'll continue to disagree, and it happens. Y'all are referencing this intox on a vehicle for 12 months as an incentive. And I think those of us that worked on this don't see that as a necessary incentive. I don't see someone choosing that option to have that on their car for 12 months and going, yay, I won. And hopefully it can invoke public policy that shows we're trying to enhance public safety by having those devices. If, as Representative Reed said, they work.
The question occurs on the Reeves Amendment AM 390149. All those in favor of the amendment signify by saying aye.
Aye.
Opposed?
No.
Chair's in doubt. All those in favor of the Reeves Amendment signify by raising your hand. In favor of the Reeves Amendment. 2, 3. Opposed? 4, 6. And the amendment fails. Are there any further amendments? Seeing none, any further discussion? Seeing none, on the underlying motion of due pass by substitute of HB 205 LC 296952S, all those in favor say aye.
Aye.
Opposed? The ayes have it, and the motion is adopted. Thank you, Chairman Rice. Wherever you are. There you are. Members of the committee, Representative Hightower in his capacity as secretary of the full committee, will go ahead and take over the balance of the meeting. I've got to go upstairs and call to a meeting. But I think we'll go ahead and, Ms. Chandler, are you ready with both? Okay. We'll go ahead and turn it over to Representative Hightower for the balance of the meeting.
I'm sorry. I thought you had Sure. She wasn't here.
HB 744. Everyone should have in front of you 2 copies. And for those that weren't in earlier, I want to explain why you have 2 copies of HB 744 and why it's important to have both those copies. One that you have is LC 296898S, and that is the bill as it was amended in subcommittee. So LC 296898S is the bill as amended in subcommittee, and you have that copy. The other copy that you need to look at is LC 336496S. That is Representative Chandler's sub to the sub. The reason that we needed you to have both those copies is because for proper discussion, you need to have what the subcommittee did and what the author has brought back. And essentially what you have is LC 336496S is the bill in its original form. So the representatives brought it back to in its original form, and the other is how the subcommittee amended it. Everybody on board on what you have in front of you and what you're looking at? All right. Representative Chandler, it's yours.
Thank you. If you'll look at LC 29689-8S first, and this was the bill as it came out of subcommittee, and you will notice that on line 12, the phrase "or employee" was added, and that is still under supervisory or disciplinary authority. And what I had tried to do in my original bill was pull this out from under supervisory or disciplinary authority, because there's so many school employees that do not have supervisory or disciplinary authority over students. So as that was done in the subcommittee meeting, I got to thinking about it, and I thought, well, I don't even know what "or employee" is. I don't know any other school employee that is a supervisory or disciplinary authority that would fit there. Someone mentioned a coach, but I don't know of any situation where coaches are not also teachers. So I just didn't see that. So I decided we just drop the bill. And then I shared this information with some folks in education, some folks in the legal world, and also law enforcement. And I decided I had to just try to go on and try to see if some other folks could not help me better explain the reason why I felt like it needed to be out from under supervisory disciplinary authority. And Representative Hightower, there are some people here that would like to speak to this as it came out of the subcommittee, if you would be willing to hear them.
No, we're here to help her with the transition of the bill, and I do want to apologize for the confusion earlier. I assumed that what came out of subcommittee was still in there, and that this was a sub that she was proposing. It is different than her original bill because it now has a different age bracket on it that was discussed in committee. So I'm here to technically help her talk about how it would work, depending on the policy this committee wants to go with. So.
He's trying to help me stay out of trouble with these lawyers. That's what he's doing. But I think we have Kelly Henson from the PSC is here to speak, and also Matthew. And Matthew, I'm sorry, I don't know your last name, who represents Page.
Give me. Ms. Chandler, in following with what the chairman had set this committee up for, and again, I'm trying to follow what was given to me kind of through the direction, is that the debate was had in subcommittee that today was going to not be for testimony outside of debate between the committee. And so we're sticking with that, and since the chairman invoked that rule himself on an earlier bill, I feel that I'm obligated to follow in kind, so not to show favoritism to a bill or to show a bias to someone. Now, I've been put in that position, not that I want to be, but since he's done that earlier today, and since that was his intent, I feel obligated to do that, because if not, I feel as though I'd be obligated to call that bill back up, which was his, and allow others to testify.
Okay, may I speak?
Yes, ma'am.
I did discuss with the chairman bringing folks to address the bill, so I don't know certainly, but he does know that. He just said the comments needed to be kept brief.
Yes, ma'am. I believe we're there.
All right, thanks. So are we? I guess it's for the committee to decide whether we want to take up which LC version we want to take up. Is that right?
Here's my battle. All right. unfortunately, I was one of the ones that came up with this sub in subcommittee. And so my struggle here, and I'm just going to be open, is that I'm trying to give Ms. Chandler an unbiased chairman, which is hard for me to do because I'm the one that helped do the sub.
That's right, you are.
So I
Well-
find myself in a difficult spot. So I could explain it if Ms. Chandler will allow me to, and I promise, as I did a while ago, I will try to be as fair on both sides I can be and just let the chips fall where they may and let this committee decide for themselves. But that's where I'm at. And that was what I was asking Chairman Golick as he left. As he left, I said, well, as chairman, when I chair a committee, I try to be as unbiased as possible, not to influence the members. But this may be a tough one because I helped write the darn sub that we're trying to evaluate. So if you'd like, Ms. Chandler, I can catch everybody up to speed on what they were and what the issues were, and that may help us.
That is fine with me.
Okay.
I'm going to be against either one of them, so you can.
And I know Chairman Setzler's here. He was there during the sub, so if I missed anything, he chaired that sub. You remember the issues that we went over? If I missed something, then Chairman Setzler, please fill in. All right. And if I'm more biased to my side, you let me know, and I'll try to make up for it on your side. All right? All right. What you have before you in LC 336496S was Representative Chandler's original bill. Really close. We changed some ages, but essentially this was her original bill. If you look at lines 12 through 15, she struck current law. If you read this properly through code, though, the provisions for subparagraph 1, 2, 3, and 4, and 5 under current law all follow under the privy of subsection B, which says a person who has supervisory or disciplinary authority over another individual commits sexual assault when that person, and then the subsequent 1, 2, 3, 4, and 5 paragraphs fall under. So all paragraphs 1, 2, 3, 4, and 5 had to be under the purview of supervisory or disciplinary authority. In her bill, what she was doing was striking provision 1 and coming up with a new subset provision, which is on the back page, B.1. And it says any person who is a teacher, principal, assistant principal, administrator, employee, or any school, of any school, is under 21 years or older, and y'all can read the rest. But essentially the crux was she was taking the portion that has always been there with disciplinary or supervisory or disciplinary authority. She was taking that paragraph out of that purview. And so to the subcommittee, that was very concerning because that opened it up to a broad array of people. And the example that I gave that day was, well, let's say you have a 20-year-old janitorial staff member who's sweeping up at night, and you have a night student that's 17 years old. One has no authority over the other, and they hook up. That janitorial staff person, based on the bill she's presented now again here, that person could be a sex offender for the rest of their life because we've taken it out of the disciplinary or supervisory category. Her concern, this is what I'm getting to your side, her concern was that there was a case that she brought up in subcommittee, which actually took place in my district. I was texting the attorney that actually defended that case while the hearing was going to make sure. I was like, man, I think I remember the facts of this case. What it had is you had a secretary from one school, I believe it was a middle school. Was that right? I think it was a middle school.
I think it was not high school. She was a ninth grade academy secretary.
Ninth grade academy secretary, but had relations with a consenting age male from that school. And when the prosecution tried to prosecute that lady, that individual, they could not do so because there was no provision in here to catch her. And so what we tried to do in subcommittee was add employee, because right now, if you look at it, it has to be a teacher, principal, assistant principal, or an administrator. Didn't have secretary, so we added employee in the subcommittee to try to catch that caveat, but we didn't want to be as unfeathered as she had originally did it, with taking it out of the supervisory or disciplinary authority. So we put it back the way it was and just added employee. So now we have added a new person. It could catch the employee and secretary if those people act in a supervisory or disciplinary role. Is that fair enough? And so that's where we're at. So you have the sub, which essentially puts back the original law and just adds or employee, which keeps it under supervisory or disciplinary authority. Or you have her sub to the subcommittee, which goes back and strikes the whole paragraph under 1 and adds a new subset, which allows it to go after anyone that works for the school, period.
May I
Yes,
speak
ma'am.
to that?
Yep.
The sub to the sub, though, tried to address some of the concerns that were stated in the subcommittee, and that was regarding the age of the actor. And so what we've added is after school, we've added the phrase is 21 years old or older. So I believe, Representative Hightower, that would take care of the 20-year-old, even though this is not what I think needs to be here, but this is what I heard in subcommittee.
Yes, ma'am.
Thank you, Mr. Chairman. I don't know if it's the appropriate time to address this. And I share this with Representative Channel. There's been some vigorous debate both in committee and out of committee on this. I recall probably 6 years ago, I don't know if it was 2010 when you guys came in, it might have been 2009, there was a case in Harrison High School in Cobb County where there was a 35-year-old teacher and a 17-year-old young woman who were having, and he was actually her school teacher. And because she was the age of consent, it was a misdemeanor. And I think Doug Collins, now U.S. Congressman, brought the bill to make that felony because of that issue of supervisory control. And there's a lot of debate in this very room about the element of supervisory control, or words to that effect, being the essential element to get into felony land. There was discussion in this subcommittee about yet another course of action this committee could take, which would be if you're an employee of the school district, 25, 21, 20, whatever, that's not in supervisory responsibility, perhaps still being a misdemeanor, so that we're still criminalizing a relationship between a ninth grade academy secretary and a 17-year-old male that's not in the ninth grade academy. That would be yet a whole nother option that this committee could take to make a criminal action, if you so chose. That's not before some of the substitutes. But I do think, I just remember, and I know Representative Randall was here at the time, that that issue of supervisory control was really an essential thing in this committee feeling comfortable making it felony. My concern is not just employees, it's also agents. I think about a 20, because I'm not just concerned about the 20-year-old, I'm concerned about the 24-year-old, the 22-year-old, say 24-year-old community coach, recent college graduate, who is a community coach on the football team. And if he has a sexual relationship with a 17-year-old tennis player he only knows incidentally through the school, should that be a felony? This committee's stance, and I think would be my stance, would be to say that, in my opinion, this is just me speaking as a member, that should not be a felony because he doesn't exercise direct control over her in this case. That element of supervisory control was the linchpin of this committee acting about 6 years ago in making it a felony for the first time ever. So maybe there's an intermediate step for people that are not in supervisory control that perhaps we would contemplate. But what passed out of full committee, or out of subcommittee, was, as Representative Hightower said, a small expansion that didn't limit it to just teacher or principal. But if there was any employee that was in direct supervisory control, then if that supervisory control element was satisfied, could be a coach, could be somebody else, maybe a secretary maybe they're doing an internship, they're working 5th and 6th period in the office as an office assistant, as some kids do. So maybe the secretary or the scheduling person might have that kind of direct responsibility over them. What passed out of subcommittee would allow the courts to charge that person with a felony if they could demonstrate the element of control for conceivably any employee, but wouldn't make it necessarily so unless they could demonstrate that element. I think that's what we're wrestling with. And I would
tend to stand where the committee was 6 years ago in saying if the element of control exists, then we're probably advised to give courts that discretion. But if the element of control exists, does that warrant a felony? The lady from Gwinnett believes it should, and I respect that. It's a policy question for us. But I just wanted to frame that in both subcommittee and for prior consideration.
Thank you.
May I speak to that?
Yes, ma'am.
And thank you, Chairman
Coomer, you're
Setzler.
next.
We have. Well, let me back up. I don't agree with you. You know that. Nor have I found any educator who agrees with you. Anybody. But I'm not a lawyer, and I don't know all of those kind of things. But we have another sub, that would address this misdemeanor area that you all mentioned. In fact, Chuck wanted me to present it that way. I don't know enough about the law. I did not feel comfortable doing so. But if you will allow him, we can pass this out and he can present it. I can't.
Yes, ma'am. Let me give a couple members who've been waiting very patiently to make some comments, and then we'll see where we're at, because we're kind of in a very unique posture. When I fill in, you didn't make it easy with a sub from a sub and now an amendment to a sub, so may have to ask for some direction on procedure in a minute. Coomer.
Thank you. Thank you, Mr. Chairman. I unfortunately missed the subcommittee meeting that we discussed this bill in, and I wish I had been there, frankly. I'm very familiar with another real-world situation in which an 18-year-old college student, a male college student, worked a few hours a week in a local high school in the office. And part of his job in the office was to collect the attendance sheets that reported who was on time and tardy and who was present and absent. He had no real supervisory control over any of the students, but a 16-year-old girl in the school decided she liked him, started hanging out in the office when he was there, and her parents later found out that these two had actually kissed and engaged in some heavy petting in the school. Now, there was no actual sexual intercourse, but that was enough for the district attorney's office to bring an indictment against this fellow and charge him under this statute as it exists today. And throughout the case, as the very able defense attorney who represented this young man told the district attorney, you're really not within the limits of this case because this young person did not exercise supervisory control. And the argument back from the district attorney, who was bound and determined to have this case prosecuted, was, well, he had the attendance sheets, so he had some level of authority, discipline, and control over this student. I am very, very uneasy with making it any easier for anyone to get prosecuted under this statute. I would support something to clarify the 21-year-old. I like the 21-year-old change. I think that's helpful. But adding the word employee would certainly have aided the district attorney in his efforts at prosecuting this, said lawyer's client. And so I would be very careful about delving any more deeply into trying to make it easier to prosecute under this statute. It's a good statute that does good things the way it is. And I would just be leery, if not outright opposed to the kinds of changes we're talking about here, other than the 21-year-old change. I like the 21-year-old change.
Mr. Chairman. Mr. Chairman, you're in a pickle. The substitute to the substitute is questionable. I don't know if we ought to not to, consider recommitting this to the subcommittee. This is far too important for us to try to rush on it. Opinions are all over the place. My head is spinning trying to decipher the substitute from the substitute to the substitute. And I agree with Mr. Coomer. Employee takes it to a whole nother level. I don't know if you'll recognize me for that, but that if I were to be recognized right now, I'd move to recommit this to subcommittee for further action, further deliberation, so y'all can sit down and figure this thing out. and to see if we indeed need to go any further.
You have a. Thank you for your input. You have my understanding that you have an additional amendment, correct?
Well, it's not an amendment. It is another substitute, but all it does is deal with the misdemeanor aspect that came out of the subcommittee. So it is a sub to a sub to a sub.
What I'm going to do is I'm going to open this up to the will of the committee. So if I have a motion, let's hear what that motion is.
Mr. Chairman, with all due respect to Representative Chandler, and we certainly have discussed this issue quite a bit and extensively, and I certainly am with you in spirit, as far as this bill, but I don't think that the full committee is ready to move yet. So if it please you, Mr. Chairman, I'll make a move that we move this bill back to subcommittee for reconsideration.
Representative Randall. All right, we have a motion to move this back to subcommittee to kind of hash this out and get it right. We have a second. Those in favor of that motion? Sorry, yes.
Mr. Chairman, I'll commit to Representative Chandler. It is, I guess, the bane of the existence of my subcommittee to hear this, but I always make the commitment that I don't let folks' bills time out for scheduling a subcommittee. So if you can work with our members of our subcommittee to get a proposition that our subcommittee can support, I'll commit to you right now to it not be an issue of me scheduling here.
Thank you.
And I just want to make that commitment. I have great respect for Lady.
I have a motion before us to move HB 744 back to subcommittee in a second. All those.
Mr. Chairman, I don't know. Is there may not even be objection to that motion.
Is there an objection to that motion? We'll do it that way. All right, hearing no objection, we'll move it back to subcommittee. And I can tell you, I've worked with Chairman Setzler many times. He is true to his word. He will help you and definitely give you a hearing on that.
Thank you.
Yes, ma'am.
Thank you very much.
Yes, ma'am.
And I'm sorry for the confusion.
No problem. You're trying to do good stuff.
Doing what I think's right.
That's right. Yes. All right, the next one will be Representative Ballinger on HB 905. You can take that from where you are if you so wish. We have to tell Setzler that that was not a lateral move. That was we needed to do that move. Oh, thank you. Hey, Representative Chandler, did you do the sub based on our conversation that we had? That's awesome, by the way. Good job. Good job. Now we're going to take up HB 905, and Representative Ballinger, the floor is yours.
Thank you, Mr. Chairman. We are working from LC 296964S. This bill kind of incorporates a couple of different aspects. I think we're going to start off, though, with Chairman Setzler had a bill that actually came before and passed out of subcommittee and actually passed out of full committee. And in order to be the most expeditious way, it does touch on child abuse and child abuse issues and some of those concerns. So we did, in a generous gesture to Chairman Setzler, incorporate that his bill into this bill. So the first portion of this bill, Section 1, just deals with that. Section 2, basically we're adding endangering a child to the mandated reporting. On page 2. And what I will do, members of the committee, Okay. We'll wait for just a minute.
Which LC are you working off of, just to make sure?
6964S.
Okay. Everybody on the same?
Everybody on the committee have that?
We're good.
Okay, cool. All right, so we are... okay, so the first part is Chairman Setzler's. So hopefully you'll be okay with that, Chairman Setzler. Section 2, we're basically adding endangering a child to that. And then I will direct your attention, the next significant change involves sexual abuse on line 92. We are basically adding mandated reporting if anybody under the age of 14 is involved in a consensual act. And I will use air quotes for that. Previous to this, it was a policy basically of the state of Georgia. If a 13-year-old was having consensual relations with, say, a 6-year-old, then that wasn't necessarily a mandated reporting issue. So we are changing that. On line 95, we do change the age difference. In one part of the bill, it actually references 3, and another part of the bill, it references 5. So we, in the lovely job of the committee work, we decided to just make the change and split the difference and turn it into 4. So on line 95, there is that change. Moving on line 117, we define Child Advocacy Center. And then skipping on, we will... online, the next substantive change is on line 202. Basically, we're giving judicial circuits the opportunity to either have a protocol committee that's either circuit-wide or just specifically for that county. Having worked with a prosecuting attorney's office where there was a multi-county judicial circuit, and then having worked in a single county circuit, it just gives flexibility to the local protocol committees to basically self-determine if they want to have that protocol committee for the judicial circuit or if they would prefer just to have it for the county. So, lines 220, it starts who the following individuals are on the committee. We basically add on line 256, Office of the Child Advocate, as far as filing the protocol. And we also add them on lines 275 and through 277. On line 298, we specify Superior Court of the Circuit. It's just basically some cleanup language. On line 287, again, we have the reference differentiating, giving local judicial circuits and local counties the ability to differentiate and choose for themselves if they want a countywide protocol committee or a circuit-wide county protocol committee. And then on Section 5, we are basically, this was at the request of the prosecuting attorneys, the district attorneys here in the state. Whenever the child abuse registry was developed, they were basically going to add convictions. As everybody is aware, I think most of those convictions are handled via GCIC, so we're just basically striking that. The reporting requirement from prosecuting attorneys, just basically adding substantiated on that. And moving on, we did, let's see. So on lines 394 to 403, that's just basically striking some of the conviction language. Moving on. Line 491, this is one of the substantive changes that we've made. This just basically allows, if there is ever a substantiated case with a minor that involves a minor, it just basically allows the minor to come off the child abuse registry. So, and on lines 505, It will. I do have a proposed amendment to lines 505. Representative Trammell was very instrumental in this change. It will read, the proposed amendment says, an individual whose name erroneously appears in the child abuse registry as a result of a clerical error shall be entitled to a hearing. So basically, if I go and I apply for a job and I'm run, I go to work for a child care center or something like that, and I find out my name is on the list just because there's another Mandy Ballinger, then this gives me the opportunity to be able to come off that registry because I was erroneously put on it. Or maybe there's two Mandy Ballingers. Someone else should be so lucky. But anyway, so it gives us the opportunity to... exactly. She gets up to lots of mischief. So it gives an opportunity to somebody who has been erroneously placed either through a clerical error or maybe they have a different last name or something like that. So it gives them the opportunity to actually come off that. So and then also at beginning on lines 534, beginning on lines 538, this just basically allows people who have access to the child abuse registry, and we're inserting on lines 557 will come out. The deletes are just basically some cleanup language, but insert at line 557 that language that is included on your amendment, and basically the CASA wanted to be able to include. So if they were having any kind of somebody volunteered to become a CASA, then they would be allowed. The CASAs could basically check for a substantiated child abuse case against that person on the child abuse registry. Because I don't think those are the kind of people that we want serving as court-appointed special advocates here in the state of Georgia. So that is the bill. And I'll be happy to entertain any questions, Mr. Chairman.
Thank you, Mr. Chairman. I had two questions for you.
Okay.
One is going back to page 10 in lines 333 where you start striking there. Is this language does this language appear in some other code section? Is it duplicative? Why are we striking?
Because basically that refers back to what prosecuting attorneys have to report to the child abuse registry, and we're striking that requirement that they report to the child abuse registry.
So is someone else reporting that information, or are we
not? Yeah, it will be reported on the GCIC. It just won't be, a substantiated case. The child abuse registry specifically has to do with defects in substantiated child abuse cases.
Okay.
Not necessarily criminal. So we're basically trying to create two lists.
I got you.
So that it has to do with that language.
Thank you. And my second question is on your 505 amendment.
Yes.
When you're adding the word, I'm looking at lines 505 through 511, and it says basically an individual whose name appears in the child abuse registry is entitled to a hearing.
Yes.
To determine whether or not their name should be on it.
Mm-hmm.
But you're adding the word erroneously, and the concern I have is, well, I guess questioning concern, if a person is availing themselves of this process, aren't they necessarily saying that they're erroneously included on the list? And if so, if you make erroneously a qualifier, are you going to prevent people from getting into this process because they can't prove they're erroneously until they go through the process?
Well, the intent of the amendment was just basically, number one, if somebody is the subject of a substantiated child abuse case, they're very aware of that, as I know you're aware. So basically, it's for the people that go and apply to a daycare agency and they get run, and then their name appears and they shouldn't be on that list. They either have the wrong John Smith, or they have the wrong person, or maybe it was Mandy, Annabelle Ballinger, and it should have been Mandy Leah Ballinger, so it was for the people that are erroneously, and just as a method for them to come off. The concern that DFACS had was that because of high turnover at DFACS, that if we didn't somehow narrow the field, so to speak, for those people that would apply or could apply to come off, that people would just wait until the caseworker had moved on or the caseworker had quit because, work circumstances or whatever, so that and they would be removed. So they were wanting to kind of narrow that field down as far as who could apply. So we were just wanting to basically, and I think the intent was for Representative Trammell to very kind of narrowly capture that person that was erroneously put onto the registry.
Right, and I see that is the intent of the existing statute and the substitute. My concern would be that by adding the word erroneously, we're going to make DFACS somewhat of a gatekeeper as to who gets to say that their name is not supposed to be on a list that's maintained by DFACS. I'm not comfortable with DFACS having the authority they have now, and I certainly don't want to give them another hurdle for people to have to jump over to say, I shouldn't be on your list. So I would, that's my concern with adding the word erroneously to line 505.
Okay. So would you want that stricken? I mean,
I'd rather we not include the word erroneously myself.
If
but
we
that's
could,
my
I think
preference.
Representative Trammell, as part of his recommendation, I think
Okay.
he'd like to have a word on it. Let's let City say on that.
Thank you,
Excellent.
Mr. Chairman. To Representative Coomer's point, I mean, the original, this was an issue that came up in subcommittee, and so we tried to, initially the expungement provision was struck, so we wanted to put it back in. DFACS had the concern that Representative Ballinger has raised about not wanting to give people two chances or to have people sandbag the first hearing, basically. So the erroneously language is simply an effort at compromise. I would be comfortable with the provision as is, but because DFACS had, and there's the bottom line is there's no pride in ownership of the way this amendment is drafted. But what it's designed to do is to make clear that we're limiting this to people who aren't rightfully on the registry. So if there's a better way to accomplish that, certainly be open to that.
And I would, to Representative Coomer's point, it would be up to the Office of State Administrative Hearings, not necessarily DFACS.
Respectfully, I've represented some folks who deal with DFACS. They're not going to go to the state administrative board for a hearing. They're going to be lucky to make it to juvenile court for a hearing. I think that sometimes the pendulum swings a little too far. I think that probably including the word erroneously, and just in my opinion, is a little too far swing of the pendulum.
Okay.
This is turning to Representative Seltzler's portion of his bill on line 4.
Going back to Setzler's adding his bill being added into this?
Yes.
Okay, can we pause?
Yep, that's fine.
Finish with the erroneous and then let me come back to that?
That's fine.
Just so we can stick on topic right here and then we'll come right back to that. Is there any other issue with the erroneous portion? I think we may take that up is when we come in for amendments, we may either leave that out or leave it in to the discretion of the committee. But does anybody else have anything they want to talk about erroneous on line 505? Okay. All right. Representative, now we're good to go. Kendrick?
Oh, sorry. So going back to lines 14 through 20, this is just a procedural question. Since it says criminal liability on line 19, this would be an affirmative defense or prevent the prosecution in the first place.
Representative Setzler, since that was your...
This would be an ability to prevent there actually being an indictment fraud.
That's it.
Does that answer your question?
It is.
That was simple. Good. All right. All right. Any other discussion? Any other questions from the committee on HB 905 LC 296964S?
Mr. Chairman?
Yes.
Follow up on Representative Kendrick's there may have been members of the full committee who were not here. What this, what Section 1 is doing is providing a safe harbor for people that are in good faith reporting cases of child pornography. Right now, you can't be in possession of child pornography for purposes of reporting it. What this does is the people who are in good faith reporting it, either law enforcement authorities or to another mandatory reporter who could be subsequently reported, this gives that person the ability to do that.
I know the discussion on that was the amount of time that
It's
will be given before they have to. Okay, 72 hours. That's just for notification. Remember, the discussion was whether
the word promptly got struck, and this was inserted. Just to refresh your memory.
Subcommittee debate that took place and then a full committee
Right.
debate that took place. And what was done in subcommittee got changed to the full committee, and what you have before you now is how it was passed out of full committee.
Yeah, it's what is waiting in rules.
Any other questions? Going once, going twice. Thanks for hitting my button. All right, then what's the will of the committee on HB 905 LC 29694S? All right, I have a motion due pass and second. Any amendments?
Mr. Chairman, I would like to make a motion to amend LC 296964S. And I'll start with the easy one. Insert beginning on lines 557. On lines 551, we will strike the word and. And on lines 557, we will strike the period, insert a comma, or semicolon rather, and the word and we will insert an affiliate court-appointed special advocate program as defined in Code Section 1511.2, which information shall be provided and used solely for the purpose of screening and selecting employees and volunteers of such affiliate court-appointed special advocate program and screening and selecting individuals to serve as a CASA as defined in Code Section 1511.2.
Okay.
That is the first one. And the second one, if it be the will of the committee, on line 505, insert the word erroneously after any individual whose name erroneously appears in the child abuse registry, and then as a result of a clerical error. Shall. So that's how, beginning on line 505, that will read, be at the will of the committee.
All right. If we could,
if Ledge Council would like to offer some guidance and wisdom, that would be awesome.
if you could speak to the Second Amendment.
So if you're taking on line 506, you're taking out having committed a substantiated case and replacing it with as a result of a clerical error, correct? Is that what you're doing?
Yes, that would be. It would be any individual whose name erroneously appears. It would read as an individual whose name erroneously appears in the child abuse registry as a result of a clerical error shall be entitled.
Okay. That language, the substantiated case language.
Yes, ma'am.
Is tied to line 520.
Okay.
And if we're only going to do it because of it's a clerical error, then I think
If we kept that language in and we put an individual whose name erroneously, we added erroneous right there, appears in the child abuse registry as a result of a clerical error, comma, having committed a substantiated case of, should we insert of having committed? Because they would erroneously as a result of a clerical error.
I think
So if we put of?
I think those may contradict each other.
Would they?
The way they present.
I'm just sorry, late
Okay.
to the dance and a little confused.
Yes.
Because if the expungement provision question is only because there's a clerical error.
Mhm.
Then it seems like OSA should only be looking to see, is there a clerical error?
Mhm.
They shouldn't be looking behind anything further than John H. Smith,
Mhm.
date of birth, this date of birth is the same John H. Smith that's in the directory.
Representative Trammell? I'm sorry.
Thank you, Mr. Chairman. I mean,
The Trammell amendment. I'm sorry.
And reasonable minds can differ on this point, but the finding that there's no credible evidence that there was a substantiated case that finding necessarily covers a clerical error.
Mhm.
I mean, you can change it to say that there was a clerical error, but that standard, it covers it. So it doesn't, to me, there's no contradiction in that. We're limiting the first, if it was the will of the committee to limit it just to applicants who erroneously appeared, the standard by which the administrative court would have to find, I think that standard works. I mean, if they don't have a substantiated case, then by definition they're there by some type of clerical error.
Representative Comer, do you want to weigh in on that since you were on the kind of opposite side of the fence there?
I'd be glad to. If you read the bill as prepared in the amendment, an individual whose name appears in the child abuse registry as having committed a substantiated case shall be entitled to a hearing. That means anyone who claims that their name should not be on the registry has an opportunity to apply for a hearing before an administrative agency judge, and they are not subject to a gatekeeping provision by anyone saying anything other than, okay, let's go have a hearing and determine whether your name's supposed to be on there or not. I think when you're dealing with essentially I don't want to tip my hand too much and say how much I dislike the whole registry, but when you're dealing with a registry where people get their names put on and they don't really have necessarily the great opportunities to contest what's on that registry, I think anytime you're limiting their ability to get in front of somebody and say, hey, this is an incorrect entry on your registry, I don't think that's helpful. I don't think it's good public policy. And as Representative Trammell said, or I think what he indicated was, your name is going to be on there erroneously if you're bringing this challenge anyway. So I think the erroneously language and the result of a clerical error language is frankly not as helpful, not as user-friendly as the having committed a substantiated case language that we have in there now. That's my argument.
I think we may have a resolution to make this go a little bit quicker.
I think, Mr. Chairman, I think I have become enlightened as we have moved through the committee process, and I think I will be withdrawing the Trammell amendment. Thanks, Bob. So there will be only one amendment, just basically adding CASA and some of the cleanup language. So yay!
So the posture that we're in is we have a move do pass, a second, and we now have the first Ballinger amendment. Is there any objection to the first Ballinger amendment? Any objection? The amendment stands as this. On line 551, you delete the word and. On line 557, you would delete the period and insert a semicolon and the word and. On line 557, you would add a number 5, and following that, it would read, an affiliate court-appointed special advocate program as defined in Code Section 15-11-2, comma, which information shall be provided and used solely for the purpose of screening and selecting employees and volunteers of such affiliate court-appointed special advocate program and screening and selecting individuals to serve as CASA, C-A-S-A, as defined in Code Section 15-11-2, semicolon. Any questions on that amendment? Any objection to that amendment? Seeing none, what is the will of the committee? Those in favor of passing this out as amended, say aye. Aye. Those opposed? There you go.
Thank you, Mr. Chairman. Thank you, members of the committee.
All right, next up, I believe we have Representative Reeves on HB 874. All right, just give us just a couple of minutes. Let everybody kind of stand up, stretch their legs. We'll start in 2 minutes. We'll go ahead and get started. What we're taking on today is HB 874 LC. To make sure it's correct, Representative Reeves, 296932 ERS. Is that correct? All right. Just for purposes of staying consistent, and I see that you've brought a large group with you. Staying consistent with what we've done with every other presenter today. If you would, I need you to be the one that gives the testimony and allow your people with you to clarify if needed by the committee.
I think it will help everybody. We have a pretty succinct presentation on this. If there's some key provisions that if they explain, it'll go a lot smoother.
Okay. All right. A little leeway to start. If it gets it too much into just straight testimony, I'm going to pull it back because we didn't allow others all day to bring up other testimony. All right, so I'm assuming this is
explanation of what we did.
okay. All right, well then we'll do that for a moment.
Is this on? Yeah, I guess I am on. All right. Well, Mr. Chairman, thank you. I've been working on this bill since this summer. The reason why I'm here right now, why we're here right now, I mean, here's a perfect example. Here's the Marietta Daily Journal in Cobb County from December. The headline, DA, gang cases doubled in 2015. In Cobb County over the last year, really over the last several years, we've started to experience a very significant increase in gang activity. And as I dove into this over the summer and teamed up with these guys who, Jesse Evans is with the Cobb DA's office, Mike Carlson's with the Cobb DA's office, and they specialize in gang prosecution. David Cook is the district attorney in Macon. From working with them, I've come to understand that this is the trend going on in the entire state right now, and so we really started meeting and getting together. We started to look at the issue and figure out what needs to be done, and so we're coming here before today. We put this together. We actually approached PAC on this. This wasn't a Prosecuting Attorneys Council's bill. This is something that I brought to them and have their support. The District Attorneys Association supported. Various law enforcement agencies. As we have had these hearings, subcommittee hearings, there's been gang prosecutors from all over the state have been present, law enforcement officers, FBI agents that deal with gang task force. There are some in the room here today that are behind us that have shown up in support of this. We've also taken recommendations and incorporated some commentary from the Georgia Association of Criminal Defense Lawyers in this bill. I do not believe that they are opposed to it. The bill has evolved, started with some things that it does not have anymore, including some mandatory minimum provisions, which I have taken those off, with the exception of the cell phone prison issue, which we'll talk about. It's really become a very pointed bill. These are some real practical changes for the purpose of strengthening the Criminal Street Gang Act. In 2006, 10 years ago, when the General Assembly revised our Criminal Street Gang Act in the legislative intent and findings, they talked about the crisis. And they talked about the need to eradicate. And that was 10 years ago. And what's happened in those 10 years, and we can talk about statistics, but I think we could skip past those and get straight to the substance of the bill, is the problem's gotten worse since this happened. And so again, what we're trying to do here is bring a few practical changes. We've got, in some situations, our laws are situated here, and we have gang activity operating at a different level. We're trying to close that gap, and that's a lot of what we've done here. There's three aspects of this bill. There's a few evidentiary tweaks of the actual Criminal Street Gang Act. We've also looked to strengthen some laws that are essentially collateral to the Gang Act but cover gang activity. That'll make sense when we get through. And the third thing is address the issue of that we've all heard about, and that's this major problem of cell phones and contraband working its way into prisons. And there's a lot of examples that we can give this committee today where gang activity is being operated and run from our prison cells across the state of Georgia. So I do have gentlemen here with me, and what I'd like to do right now is go through the bill. If it actually helps to go out of order. So if everybody can turn to page 5. We're going to start at section 6. Before we do that, I think that in order to really understand the changes, I want for Mr. Evans to give a 2-minute or less crash course on how the Criminal Street Gang Act works. I think it will help the committee very much be able to comprehend why some of these changes are important. And so if it's okay, I would ask Mr. Evans to kind of use your handout to explain.
Representative Reeves, I'm going to try my best to give you a little leeway, but when the chairman left, he didn't let other people testify to the bills, and that's how he gave it to me. And so earlier this afternoon, we didn't let any testimony come in except to clarify questions of the committee. I don't want to stifle your presentation, but I really want to be fair across the board. That's what he did for the first 5 bills. We'll hear little, but I really need you to walk through the bill, and then if we have questions, I think that would be an appropriate time for them to kick in and answer any type of questions that people will need clarification on.
Well, I certainly think it would benefit the committee to have a little bit of explanation and background. The Criminal Street Gang Act operates in a way that's extremely different from...
Give me 1 second.
Sure.
Mr. Chairman, I have a question. I'd like to know how criminal street gangs work. I think that might satisfy the committee.
There you go.
Be loyal
I was
fair.
trying to throw it out there.
Thank you.
I was trying to throw it out there. If you would, help us understand.
The handout that we provided to the committee shows the 4 basic components that must be proved beyond a reasonable doubt by the state to prove a gang charge under 1615-4 Part A, which is kind of the main gang charge. If you start at the top, the first thing we must prove beyond a reasonable doubt is the existence of the gang, which is shown by the proof that there's 3 or more individuals associated formally or informally. And the important part is that they engage in a pattern of activity. They've engaged in criminal street gang activity. So you can't just charge a rap group, can't just charge the Boy Scouts. It's got to be somebody, a group of individuals engaged in activity. That's step 1. Step 2, going around the circle. You have to prove the defendant's membership or association with that criminal street gang. Step 3 is proof beyond a reasonable doubt that the defendant has committed some new enumerated offense, such as a drive-by or a shooting or a murder. Step 3 is actually 4 is actually a court-imposed limitation called nexus, and our courts have basically said, well, you have to have some connection between the charged activity and the street gang in order to charge them. You can't charge a gang member with violation of the Gang Act for a family violence battery. You could charge for a battery that happened at a school between rival gangs. The first issue that Section 6, we're trying to correct here on page 5, is that there's an embedded evidence code in the Gang Act under 1615.9 that basically currently says the commission of any offense committed by any person as a member associated with a gang can be used to prove that this is a street gang, that's what by definition they are. What we've realized is after being passed in 2006, the evidence code was passed in 2013. Rule 803.22 has a specific exclusion for the use of third-party convictions in criminal cases. You have an anomaly then where you have an ambiguity in the law from the 2006 statute that allows for us to, requires for us to be able to prove the existence of the gang by showing this pattern activity, and then a hearsay rule in 803.22 that would seem to preclude our ability to bring in adjudications and convictions, which typically are the highest and best form of the proof of those committed offenses.
And Mr. If there's any questions about further, Mr. Carlson was very involved to my left here with the evidence code back in 2012, 2013, and has is published on the rules of evidence and was very involved in kind of our conversion to federal rules. When we converted in 2012, 2013 to the federal rules, this hearsay exception was a federal hearsay exception that became part of our Georgia law, and it, again, as Mr. Evans said, created an ambiguity or conflict with 1615.9. The federal rules of evidence do not have or the federal law does not have a street gang act like ours. So there wasn't really a precedent for us to see federally how this hearsay exception impacted something like our street gang law. And so what we've seen, and so it wasn't anticipated, it wasn't discussed, wasn't anticipated, and what we've seen since then is that this hearsay exception is being used to successfully exclude evidence that goes to the cycle of what has to be proven, which is what was allowed in 2006 when the Street Gang Act was passed by this body. And so what we are trying to do, this new hearsay exception is not was not intended to do that. So we are just trying to create clarification in here that the this hearsay exception does not apply to 1615.9.
This is a great presentation. I appreciate you doing that. I wanted to understand, under the current state of the law, what is the additional, if all four of these circumstances are proved, what's the additional bang the prosecutor's able to bring to bear if a violent or crime is proven to be part of a criminal street gang related crime? What's the extra? Is there a difference in minimum sentencing? Is there an add-on? Can you describe that in committee for us again?
By statute, the gang offense is a separate offense. So typically you'll have an aggravated assault for a drive-by or a murder or whatever it may be. And then you have a standalone gang charge as well that gives some additional penalties. Also by statute, there's a no merger clause that there's as well. So it would allow a judge in some instances to potentially give a consecutive sentence. In some instances, it's actually required when you deal with leadership and some of the other charges that also have this definitional requirement of what is a criminal street gang and how we prove that in terms of this pattern activity.
So if they're an aggravated assault or drive-by shooting that they miss, but they don't kill the person, but you're able to definitively prove it's part of this, you're able to really put some years behind it?
Absolutely.
What's the minimum, what's the maximum for a standard?
It's 5 to 15. under an A offense. There's actually 10 different listed offenses. All of the offenses refer back, though, to the existence of the street gang, so that's the common denominator of all of the 10. The one that we use most often is under 1615.4A, which is the subject of the chart that's been provided, and it's 5 to 15 years. For some of the other offenses that come thereafter, I believe involving leadership and recruitment, there are some additional penalties and requirements for consecutive time, but now available to the courts would be 5 to 15.
Representative says, let me explain another element of this as well. This is essentially a narrower version of racketeering laws, specifically tailored for criminal street gangs. Prior to 1970, there was not a single successful Cosa Nostra prosecution in America. And that was because the laws, whether it was murder, extortion, did not allow the jury to get the evidence that the mafia was behind the activities. When RICO passed, it of course took prosecutors about 10 years to start using it. Imagine, for a second, the amount of crime that continued until that started. And the reason RICO was successful in dismantling the mafia was because of the evidentiary pathways that it created, so the jury could become fully educated about the shadow that was behind and actually controlling whatever immediate crime it was, whether it was raising garbage prices or murder. The Gang Act allows that in Georgia, and it allows juries to know the context of the drive-by shooting that we have here, and that there's another force behind it, and that this drive-by shooting is actually part of a continuing act of war against whatever community it occurred in. And that includes not only acts of violence, that includes acts of recruiting and any a number of offenses that would classify as a Gang Act violation.
And that also relates to the cell phone provision that you brought up, and is that they get context for what the phones are being used for, and how we have wiretaps right now where we've shown that they're using these wiretaps to order additional hits on other citizens even while they're still in jail. That's happened right there in my jurisdiction. So by them hearing that this gang exists, what this gang does, and then what they're doing with the phone, they get the full picture as opposed to what's the big deal, he's just talking to his girlfriend.
Thank you. Could you walk us through Section 7 and the evidence provisions, and you or one of your learned colleagues help us understand how that's different than what exists in the law now and why it's necessary?
Mr. Carlson, can you handle that?
Absolutely. Representative Cooler, we fashioned this after existing evidence code provisions, and so that we would maintain consistency across the board, and also so that there would not be a question as to the form. As Mr. Evans pointed out, there are additional burdens when a case is indicted under the Street Gang Act. One of them, we have to prove the existence of a criminal street gang. We also have to prove that this individual defendant is a member or associate of that criminal street gang in order to create one of the various connections we have, or nexus, of course, being the term the Supreme Court used. What this statute does is pertains to the individual defendant and that individual defendant's prior gang activity, and provides an ability to bring that evidence in, provided that the state gives notice ahead of time. There's a little bit of a gray area in terms of our adoption of the evidence code, and I don't want to take up too much time with that, in terms of whether or not the state would have to provide prior notice of the previous gang activity of a particular defendant. And then that gray area could lead to other unnecessary evidentiary conflicts and issues. This clarifies it. It puts a burden on the state in terms of notice, provides opportunity for a hearing, but then at the same time creates an ability to bring that evidence in through a specific statute rather than a generalized, well, this is all intrinsic, this is all about the gang, it ought to come in willy-nilly.
Here's the Criminal Street Gang Act, which says what kind of evidence could come in. What 24-4-418 does, it's the avenue. It lays out the avenue for how we do that, creates obligations of the state. I think it just solidifies the next step of exactly how this is supposed to be offered and done.
Thank you. I think we just justified our CLE exemption. Thanks.
If everybody can now move to Section 1.
Thank you, Mr. Chairman. As we go forward, I don't want to hinder the testimony, but I can't help but add, the paper here that you provided, 2014-34, I guess, 34 gang-related activities. 2015, 62. That's doubling it. Are we seeing this in neighboring states, Alabama, South Carolina, Florida? Are we seeing this, and what are they doing? Are we going to be kind of the standard bearer if we're able to get this legislation in, or are we leading the way, or are we following some other state models?
I think Mr. Carlson is best equipped to
Well,
answer.
we have members of the leadership from the Georgia Gang Investigators Association here as well. Federal government does studies comprehensively, not every year, it's usually about every 3 or 4 years, in terms of exploring the numbers of gang members across the country. The most recent comprehensive study was 2011. It estimated 1.4 million gang members in the country committing between 40 to 90% of the violent crime in America. That number increased by 400,000 from just 2 years before. Some folks thought, well, maybe those numbers are inflated, so some academics last year at Sam Houston State University did a self-reporting study of gang members, and as it turns out, those numbers from the federal government are probably off by 2/3, so multiply that by 3. Our gang statute is by far, and this is not conjecture, this is by studying all the different states, by far the strongest but also the most fair to defendants because, as Mr. Evans points out, it requires an actual crime to have been committed first, and then we can bring the additional gang charges on there. Other states are coming to us, and members of the investigative community, also prosecution community, in order to create statutes like ours. Again, the problem is this is a burden that states have to bear because there's no federal gang prosecution law for adult offenders.
And you see the impact immediately when I began using this statute the way Mr. Carlson recommends and following the case law as he recommends. Our homicide rate went down 25% the first year, and the next year it went down close to 30%. In 2015, when jurisdictions my size had a huge spike in homicides, mine were roughly half what similar jurisdictions were.
We have a representative from LaGrange Police Department here. I know they had similar results. I've coordinated with Scott Ballard, the district attorney down in Fayette County. One successful gang prosecution of a initiation beating in a bathroom by a gangster disciple members. That's a gang out of Chicago, an aggressive gang act prosecution, lowered gang incidents in 6 months in their schools. He told me about 50%.
Guys, the more we keep talking, the more questions y'all are getting. So, Representative Atwood.
Mr. Chairman, this is not new. I mean, I can remember back when I was in the days of wooden ships and iron men. We had we worked very actively on the outlaw motorcycle gangs and other ones. I mean, the Dear Fuzzy Hells Angels that I see on TV carrying an Olympic torch, which sets me over the top. Back when they did it, they controlled had the largest catering service in California. The outlaws controlled the precursor market for illicit drugs out of Canada. I mean, these were major operations that they had, and we were using every tool that we possibly could to combat them. So anything that we could do, I think, to help this would be well served.
Thank you, Mr. Chairman. Can you help me with? I mean, the part that concerns me a little bit is the evidence provision. It seems like we get the benefit of an exception to the hearsay rule, and then we're also putting into statute that it's statutorily relevant. So my concern is what are we not getting now in cases that this is designed to address?
Explain your.
So in a murder case involving gangster disciples that dumped a body off of Circle 75, one of the things that we wanted to do to prove the existence of this very well-known street gang out of Chicago, we have to, by law, or the judge will be reversed, show that there's some criminal activity other than the charged offense that the gang has been involved in. One of the defense attorneys in the case, Mr. Bruce Harvey, tried to use, and successfully used 803.22 to try to preclude our ability from using certified convictions of other gangster disciples who had committed gang activity to prove part one, the existence of the criminal street gang. So you had a situation where the 2006 statute was passed, and then 2013 unintended consequence that would appear of the evidence code is that there was this blanket exclusion of our ability to prove the convictions of other gang members even though that seemed to be at odds with what 1615.9 would prove. Commission's very broad. That would include, obviously, conviction, adjudication, even uncharged crimes. But it limited our ability to prove that first essential element, that the gangster disciples were indeed a criminal street gang versus some group of individuals.
Mr. Chairman, if I could ask a follow-up question. Is there an analogous provision to what you're proposing with respect to racketeering in the President Evidence Code?
It winds up not being necessary federally with regard to RICO cases because the 803.22 doesn't appear to be used that way. The provision exists there to protect an individual criminal defendant from convictions of someone else that might be used against him to prove he's guilty of whatever crime there is at bar. Other uses tend to be allowed, and this would, we believe, classify as another use because we're proving that the gang exists rather than the individual committed the underlying offense.
Essentially, we have a statute that's been held constitutional. Since that time, there's been the new evidence code, new challenges, and so we're seeking to clarify to bring us back to where we were so that we can continue to use this.
All right. Representative Strickland.
Mr. Chairman.
We're about to speed up a little bit, guys.
Yes, in fact, we're now through the most complicated part of the bill. I can.
Representative Strickland, let's go with your question.
Representative Reeves and our subcommittee, which I know we're in a small room, but just two of us sitting there, but we spent a lot of time on Section 1. Do you mind just briefly going over that section? I know that was brought up a lot by Representative Pack and myself.
Sure, Mr. Evans, if you can kind of talk through Section 1.
Consistent with what we just talked about for Section 6, Section 1 is a provision of the Juvenile Code that limits when you can use juvenile adjudications. That, again, would be at odds with 1615.9. So this is just a bit of a cleanup to make sure that this code provision is also consistent with how 1615.9 was adopted in 2006.
And with this, we've also worked the Barton Clinic, and I know that there's a representative from the Barton Clinic here in the room today, to add on lines 30 and 31. Obviously, their mission is in all things the protection of children, and we, upon their working with them, have added lines 30 and 31 to offer that adjudications offered in this way, pursuant to this code section, will be offered under seal. Okay, so moving along now, we can probably get back to just the order of the bill. Section 2 is the tampering with evidence code section 1610.94. What we have done here is, and as there are many examples of this happening in gang cases where a person will attempt to cover up their act or destroy evidence to conceal the criminal gang activity. But in general, this code section has an inconsistency out there. As it's written now, as the current law is, it is a felony for you to tamper with the evidence of somebody else's felony crime. So if Mr. Evans is charged with a felony and I go and conceal or destroy the evidence, I could be charged with felony tampering with evidence. However, if I did that to my own evidence, if I was charged with a felony crime and I destroyed or concealed my own evidence, it is not a felony. And so just look to change this statute to bring that where it just kind of add a common sense where it may be lacking right now. I don't think that is correct the way that it's set up right now. Section 3 is the Sure.
So 1610.94 applies across the code for anyone charged with felony, but this isn't specifically within the gang statute, correct?
That's right. This is not within the gang. This is what I would call a collateral code section that certainly has implications that gang members are oftentimes charged with tampering with evidence. And this criminal offense is one of the predicate criminal offenses listed in 1615.3. In order to be charged with a gang, again, going back, a predicate offense has to be listed in 1615.3, and this is one of the listed offenses.
I mean, isn't it? I'm just trying to unpack this. I mean, no one wants to carry water for felons, so that risk of being seen doing that. I mean, isn't it customary for any crime that someone commits? There's going to be is it fair to say that there's always going to be an effort to cover up one's own evidence? It's all part of the whole subterfuge of getting away from something. Would this not have the effect of just creating another offense, that if someone murders somebody and buries the body, that the burying of the body now becomes another offense to stack on top of murder?
It could be. I don't see why it couldn't be.
And I'm just for purposes of clarity, that's a policy question that we wrestled with.
Do you?
I didn't read this to be specifically within the gang statute. I wanted clarity more than anything else. So if someone were, and this would apply for any felony. So if there was I'm going to unpack this in my mind for a minute.
Okay. Moving on to Section 3. This is the terroristic threat statute.
Could we get to answer his question though? This is not just in context of the gang.
That's
statute.
right.
So the way this would be construed is any charge.
That's right.
Correct?
That's right.
Okay.
That's right. Section 3 is a terroristic threat section. There's essentially three things that we've done here. The first of which is lines 64 through 74. There's no substantive change. We have just restructured the way that it appears in the code section. It's a very confusing. I've been working on that code section as a prosecutor and defense attorney for 10 years. And so it's we have basically restructured it so that it is easier on the eyes and easier to read. Did you have a question?
Yes, but I'm going to bring you back because I got down to the bottom of Section 2, and in lines 54 and 55, it says, so misdemeanor and involving himself, herself, or another person shall be guilty of a misdemeanor. So is it that same provision on misdemeanor cases as well?
If the offense is a misdemeanor offense, then the tampering charge is a misdemeanor offense. So if you're charged with a misdemeanor offense and I tamper with your evidence, then I'm subject to a misdemeanor. If I'm charged with a misdemeanor and I tamper with my own evidence, I would now be subject to a misdemeanor as well.
And I get that. But looking at this, and you and I have talked about things, I try to look at things as how they could be abused. And I know we have great prosecutors, and I know that we have people that use great discretion. But when we open up certain things, just want to make sure, as Chairman Setzler does in the subcommittee, that we unpack some of the possibilities that we're looking at. So in this situation, let's say that you have someone that's getting pulled over, and we'll just relate back to what we were talking about earlier, DUI. They're getting pulled over with a DUI. And that person, as they're getting pulled over, they chunk their beer can out their window, right, at the very last minute. What we're doing here, essentially, let's say that for some reason the person gets off their DUI case, but they're convicted of, or they get off the DUI case, you then have a new misdemeanor charge of possibly tampering with evidence because he threw the beer can out the window. So you could have a prosecutor who could theoretically be upset because they losing their they know they're not getting the conviction on the DUI, but they now can pursue their new misdemeanor of not only littering, because it'll be littering in my example, but a new charge.
I think I can help.
Of misdemeanor.
This can happen right now. Okay. Right now, the scenario you just described, our laws allow that. The issue is the felony. The difference.
But I thought the reason I'm asking is because the way you present is that now we couldn't do that. You said that it's someone else, but as long as it's you, the current law doesn't. So is current law you, or is it not you?
Currently, right now, you could be charged with a misdemeanor. The way I interpret the law right now is you could be charged with a misdemeanor for tampering with your own misdemeanor case. You could also be charged with a misdemeanor for tampering with your own felony case. The difference is you can't be charged with a felony for tampering with your own felony case, but you would be charged for a felony for tampering with someone else's felony case.
Okay. Chairman Coomer?
My questions relate to the next section if you want to.
Yep. Okay.
Section 3, again, 64, lines 64 through 74 is not a substantive change. It's just rearranging the elements of committing a terroristic threat. It's a confusing statute right now, and I thought that while I was in here, I wanted to use this as an opportunity to make it clear. The second change, if you go down to 90 through 92, is we have created a misdemeanor offense for terroristic threats. And this is something that I feel strongly about from my years of handling these cases, again, as both a prosecutor and defense attorney, that oftentimes the conduct that is captured in a terroristic threats charge, to me, doesn't rise to the level of a felony offense. And so I thought that it was appropriate to create a misdemeanor offense unless the terroristic threat suggests the death of the person, the recipient of the threat, in which case it would be a felony, but all other instances would be a misdemeanor. The last section, and
hold on one second. Chairman Coomer, you had a question to that section?
I do, and I think this question might be the Legislative Council, and maybe this is a Legislation 101 question. But I went back. I was a little confused by the way we started drafting this section on line 60, and so I went back to the code to pull it to see if I could get some context, which of course is always dangerous. And what I found is the code that we have, the 2015 version of the code, does not match the language in Section 3 for OCGA 16-11-37. And I say maybe it's Legislation 101 because my understanding is when we're changing existing code, we have the original language there and we have the strike-throughs for whatever we want to delete, underline the additions, and whatever's not changed you leave as plain text. But that's not the case, and I'm wondering if there's a reason for that we don't have the original code in this section that we're changing from original code.
I don't know if you're looking at the supplement or if you can direct me.
I'm looking at LC 296932 ERS.
I know, but if you could direct me to the line of where your concern is.
Well, let's start with line 60.
Okay, well, if you will direct your attention to line 65, you'll see that language. It's just moved.
I don't understand you.
Hazardous substance, if you look at line 65, says, as such term is defined in Code Sections 12-8-92. All we did was move that to the beginning.
Okay, maybe I'm not. Let me start with this. I look at the current code, 161137, and the words begin, Section A, a person commits the offense of a terroristic threat when he or she threatens to commit any crime of violence, to release any hazardous substance, as such term is defined in Code Section 12-892, or to burn or damage property. And it goes on for several more lines, but that's not the language.
It is. If you look at line 62, that's where it begins.
At line 62.
The definition is pulled out.
Oh, gosh, okay.
It's split across a bunch of lines.
Well, that's why I didn't understand it. Maybe.
Crafty, eh?
Okay, that leads me to the next question. Reading down through lines 60, if I may, Mr. Chairman, 62 through 67, what it says, a person commits the offense of terroristic threat when he or she threatens to commit any crime of violence, release any hazardous substance, or burn or damage property. But and I guess why I'm confused is because I thought that stuff in the existing code then tied into the purpose. So if you do those things with the purpose of terrorizing another, then you've committed a terroristic threat. But the way it's drafted out here, when you commit those acts without reference to any purpose, you've committed a terroristic threat. Am I misreading it?
Yeah, you just drop down to line 68. So you do those acts, and then on line 68, see there's a comma after property on line 68. On line 67. So imagine taking out the number 2 and making it a lowercase s for such. So those acts above, those terroristic threats, have to be made A, with a purpose of terrorizing another, or B, with a purpose of causing, etc. And I will tell you that Representative Reeves and I went round and round to try and make this work because it is in current law completely confusing, but I do think that setting it out accomplishes the goal of you have acts, but those acts have to be done with a purpose.
Okay. Thank you very much. I appreciate your effort at making it much easier to understand.
I don't know if we got there.
I'm not sure I'm smart enough to get there, but thank you very much.
moving on to page 4, lines 101 through 105. This is the change to this code section that relates to gang activity collaterally, but this part of the terroristic threat section currently allows for or calls for if a terroristic threat, or I'm sorry, if a terroristic threat or act is committed in retaliation for anybody who essentially interferes with the judicial process. If they threaten or commit a terroristic act against a judge, a witness, attorney, clerk of court, deputy, court reporter, so on and so forth, then it calls for the specific sentencing there. It's an enhanced penalty. I thought that since one of the key issues that we face in criminal street gang law enforcement and prosecution is the threatening and intimidation of witnesses and those in the judicial process. I mean, that's really, I think if you ask any of these guys what's their biggest obstacle, it's getting people to come to court because they're scared to come to court because they are threatened if they come to court and testify. And so I thought it was appropriate to open this up, not only to allow for this to apply to those that retaliate, meaning against somebody after they've testified, but also to add intimidate or threaten so that we cover that same conduct before they testify, because the threat is the same. And so I thought that was an appropriate measure, trying to deal with the fear and intimidation tactics of gang members, and that's the best place to do this. Section 4 is simply a cross-reference to the terroristic threat, so there's nothing substantive there. Section 5, this is the offense and sentencing section of the Criminal Street Gang Act. So now we're back in the Criminal Street Gang Act. What we have done here is a couple of very simple changes. As current law is, the sentencing time frame is 5 to 15 years. We have changed it to 5 to 20 years. The reason why our RICO violations are 5 to 20 years. So we added time on the end to basically mirror what the sentencing is for RICO violations. Figure that white collar RICO type fraud, the sentencing that applies to that, certainly when we have the violence and what these gangs are doing in the communities, that it was appropriate to have those mirror each other. The other thing that we have done is that if you are convicted of being a gang leader, this is in line 150. It says any person who violates subsection D of the Criminal Street Gang Act. D is the section that deals with gang leadership, management, supervision. If you're convicted under that code section, your time is consecutive to any other sentence. And the other thing, if you go down to line 155, section E, F, G, H, I, and J, currently the minimum is, this was, I believe, 3 to 10 was the range, and we have changed this to be in conformity with the 5 to 20. And the reason why is because in line 155 is really kind of where we pinpoint what I consider to be the true kind of essence of this gang behavior. These code sections deal specifically with harming somebody because they won't join a gang, harming them because they try to leave the gang, harming them because they refuse to join the gang, harming them because they are going to testify against gang members. This is the conduct right here that's killing our communities. And I thought that it was certainly originally I had mandatory minimum prison sentences in this code sections. I've come off of that, but I do think it's appropriate to mirror the rest of the actions with, or the rest of the sentencing with 5 to 20 years. If you move back up to line 143. This is the provision. This references code section 42-5-18, which is the penal institution code section. This is the code section that deals with contraband in prisons. And so what we've done here, we've done two things. The employees is later on in the bill. That's what I'm about to get to. We're almost done, y'all. But for inmates in a penal institution that are convicted of using a cell phone or using contraband in furtherance of the Criminal Street Gang Act. So this is really important. Here we are, y'all. We're back to this, okay? We're back to this, which is probably the highest burden in Title 16. If it can be proven by the state that a gang member is using a telecommunication device, is what the definition is in Title 42, to further the street gang act, they're running their gang from prison, then the sentencing would be 5 to 20 with 5 years to serve as a mandatory minimum. This is a very specific, unique issue that we're dealing with. I worked with Department of Corrections back in December in kind of finalizing this legislation, and they're in agreement with the issue. I think probably everybody on this committee heard last week about the federal indictment of 49 correction officers in the state of Georgia were indicted. This problem, I don't need to go over it because I think we all know the significance of this problem. There is corruption going on at the ground level, and inmates are being given lots of things they're not supposed to have, including these cell phones. And if anybody wants to hear some examples, we can talk about them here. But there are examples as detailed as a hit on a prosecutor being ordered from a gang member in a North Carolina prison that resulted in the prosecutor's father being kidnapped and brought to Georgia and was actually rescued in Cobb County. These are the things that are happening. Mr. Cook can give some examples as well of things that are going on in his jurisdiction. So I feel very strongly about this provision. I think we have to be strong. It's a 5-year consecutive sentence. If a gang member uses cell phones to run their gang in prison and they're convicted, they're going to extend their stay in prison. The last section...
Which line are you on?
Apologize, y'all. That is lines 143 through 149. The last section of this bill, Section 8, which begins on line 188, is the other side of the coin from what I just described, and that's the essentially the employees or the persons that are helping and aiding and smuggling in the contraband, such as cell phones. This is where the problem is happening. There's stories about soccer balls being kicked over the fence, or a drone that were filled with cell phones, or a drone flying over and dropping off a cell phone in the yard, inside the fence. But where the majority of these devices and contraband is coming through is they're being smuggled in by the employees that work there. And so again, now we're back in Title 42. If this amends or changes the sentencing aspect of this code section to say that if an employee or a person violates this and is convicted, then their sentence would be 2 to 5 years with 2 to serve as a mandatory minimum. Again, we are trying to address a very specific crisis that's going on. I understand, and trust me, I've heard throughout this entire process the concerns about mandatory minimums, and I had a lot of general mandatory minimums in this bill initially. I've taken them all out, but I do not believe that we need to compromise on this area. I think that these sentences are appropriate to deal with this issue. This is the first step. The second step in this cell phone issue really gets into some technology issues. I'm committed to staying with it, and I'm going to work with DOC and other entities in the off-season to see what can be done next year to continue to try to combat this. So that's my bill.
Chairman Coomer.
Thank you. I just wanted to talk about the sentencing provision that you were just discussing for a minute. And I appreciate that there are not mandatory minimums throughout the bill, but the mandatory minimums, and again, if you look like at line 145, mandatory minimum term of imprisonment of 5 years, that would mean that the judge really has no discretion to sentence a person to a probated sentence of anything less than 5 years. I mean, they couldn't probate any of that first 5 years. They're going to jail for 5 years. They're going to prison for 5 years, regardless of the facts of the case, if they meet the bare qualifications, regardless of their criminal history. And I've heard from my Superior Court judges over and over and over for years about the bane of their existence being mandatory minimums. And really, as a policy provision, it's appropriate for us to have mandatory minimums as a General Assembly when we see areas where we think the judiciary is too lenient. If we think that people who commit a DUI should be in jail for 30 days for their second offense, and that the judge should have no discretion in that, and we think judges are too lenient, that's an appropriate place to make those kinds of changes. I'm concerned here because we don't have any evidence before us that judges in superior courts are being too lenient on gang members. It sounds like we just need the tools for prosecutors to prosecute the cases, but it may be premature to make the determination as a matter of policy. Judges should not have discretion to sentence somebody for less than 5 years in prison in these particular issues. What do you think?
I think that the context of if somebody is in prison, their motivation to not violate the current law is minimum because they're already in prison. The only legislative change that we are going to be able to put forward that is potentially going to change that conduct and make people think twice about whether or not they want to do something is if it does mandatorily extend their stay in prison. Again, this provision goes back to this chart right here. We don't get here without going through this, so we've got a very difficult burden. If we could, and I think Mr. Cook can talk about some of the cases in his district or his circuit with this, but we are talking about some very serious. Danny Porter has shared with me the string of jewelry store burglaries. It's more than just violence, more than threatening. It's criminal enterprise. Being ordered from a prison, a string of 11 jewelry store burglaries in Gwinnett County, ordered from a gang member in prison. Very serious offenses, and I think that if we are going to answer this problem, if we are going to try to create a environment that is going to dissuade somebody from doing this, we got to be tough on this.
And I agree that the person in prison who's manipulating the 11 jewelry stores robberies should be sentenced harshly, very severely. I mean, he's obviously got a much significant culpability, but I'm not sure that the 19-year-old who is throwing the brick through the window because he's been ordered to do so necessarily should go to prison for 5 years because he's part of the same criminal enterprise.
Well,
and I'm not saying he shouldn't.
He wouldn't be if he's the guy throwing the brick through the window. He's not. This would apply to the person in the prison cell using the illegal telecommunication device, ordering the activity. I mean, this is a significant issue. Mr. Cook, do you want to?
I mean, we've had significant problems with gang members using phones to order hits and other criminal enterprises. They were running insurance scams on the small side, right? But on the big side, they were planning which witnesses they were going to kill for our upcoming trials. Okay, and so this is who this applies to: is that people who were in jail using phones to further the interest of the gang. That's who this applies to. I mean, I'm actually not a fan of mandatory minimums myself, and I talked with Bert about that. But on this one particular one, I said, no, on this one's different. And 5 years is the minimum I recommend right now for people who are smuggling cell phones into our jail, and sometimes the judge follows it, sometimes they don't. I had a guy who had been in the military, and he was a prison or a jail guard, and he smuggled in phones to some gang members who were planning these hits. And I recommended 5. It's the most I could get, and he gave him 3 because he'd been in the war. So,
well, and I'll just finish with this, if I may, Mr. Chairman. Again, we are increasing the maximum prison time to 20 years, so you'll be able to argue in those serious cases for 20 years, stacking them up if they got 3 or 4 or more. But as a matter of public policy, I don't think we have before us evidence that judges are sentencing people too lightly to the extent that we need to create a mandatory minimum in the statute. That's my final comment.
You'll have an opportunity here in a minute.
Well, and my comment on that is I think if we're not strong on this, then we're not going to achieve any results. And
Representative Reeves, anything further on your bill?
No.
All right. Yes.
The question on the communications thing is where I'm trying to understand exactly how this operates. Because I think the circumstances you're talking about, I think certainly for me, you're going to find friendly consideration for someone who's ordering crimes. Does the language here, and I want to walk through this, does the language here allow people who are in prison who are communicating through telecommunications devices things that are part of the gang enterprise, but they're not directing hits, or that are furthering direct criminal actions. Is there a, I want to understand whether if you've got if somebody were a 21-year-old gang member, maybe they've got 3 felonies on the record. I'm not saying they're a good guy or gal, but does this allow a prosecutor to say, you know what, you've got a phone in prison, you're communicating about gang things, and this gives us an ability to hit you for 5 years?
In order for any of this to apply, you have to be engaging in a communication or ordering an activity that falls under 1615.3, which is the list of predicate offenses. Again, that's what limits our universe here. Calling your wife to tell her that you love her doesn't fall here. This is limited to the predicate offenses in 1615.3, which any gang case has to have in order to be made.
So if they're okay, and that's a pretty broad group of things from theft to breaking and entering to murder to pretty broad. I'm just trying to understand, and I'm just not having the opportunity to be on the town subcommittee representative. And some of you folks have. I just wrestling with this. Okay.
All right. Appreciate the discussion. Appreciate the presentation. What's the will of the committee? Sorry, hold on 1 second.
I was going to make a motion.
All right. This is the appropriate time.
This will be House Bill 874, LC 296932 ERS.
All right. Have a motion and a second. Any discussion? Any amendments?
First amendment I offer is on line 90.
Go ahead. I didn't have your mic.
On line 90, striking the word for.
Okay. Do you want to do these as individual amendments?
Probably be easier.
All right, so that's Amendment 1. Striking on line 90, the word for. Okay?
Can we go on?
Amendment 2.
Okay. The second, and actually it may be broken up into
What
2.
we can do, any objection to Amendment 1? Any objection? All right. Amendment 1 goes, passes.
Okay. And I think this would actually be 2 more amendments. I apologize. I have trouble counting to 3 sometimes. On lines 145 through 148, where the word, basically I want to strike out the mandatory minimum language. And I'm not sure council can figure out how to do that. But the intent would be to remove the mandatory minimum language.
You would on line 145 take out a mandatory. On line 146, you would take minimum term of out. After the word imprisonment of, you would replace that with for to be consistent with the language in the other parts of the subsection. On line 147, after the word impose, you would take out the balance of that sentence all the way through the end of 149.
Can you read it back to us? How it would be?
Can I start just on line 145?
Yes, ma'am.
Thereof, comma, in addition to any other penalty imposed, comma, shall be sentenced to imprisonment for 5 years, but not more than 20 years, which shall be served consecutively to any other sentence imposed, period.
All right. That's amendment number 2. Is there more
And
down?
I think, if I may, counsel, should we also strike the, or did you strike the rest of that and no portion? Okay.
Yep, that's all.
Okay.
Stricken.
And fix the title.
That would be my second amendment
All right.
offered.
And let's move on that second amendment.
Can I, as author of the bill, speak on that?
You can. Please do.
I am urging this committee to please not vote this amendment. I believe that this is a serious problem. We have all heard about it. Some of you have prisons in your districts. You've heard more about it than even I have. I worked with Department of Corrections in coming to these terms. I'm asking this committee to not pass this amendment.
All right, if we could.
I have a question, Mr. Chairman.
Yes.
I recognize I'm slower than some of the other kids here. I apologize. In terms of applicability, does this apply only to our prison system? Does this apply to
Penal institutions. It would apply to any penal institution in Georgia.
So if you're in county jail,
That's right.
There, but would it apply to, you had a cell phone, if you're doing work release or something like that, and you had a cell phone, would it apply to somebody that's in some kind of transitional or partial custody?
The Title 42-5-18 lays out what is contraband for any inmate. If they're considered an inmate, then it would apply.
And to answer your question, I think that it would, because they would be in the custody of that institution. So I think they are still considered an inmate even if they're on work detail.
Your concern here is that it's got to be ordering something that's one of the predicate offenses. It's not something that's just you're using a cell phone.
That's right.
All right. All right. Any further discussion on Coomer's amendment number 2? Yes.
Thank you, Mr. Chairman. I just want to echo what Representative Reeves said. We discussed this in subcommittee as well. I think, of course, I'm on the other side of town in Henry County. We're also seeing gang violence on the rise there. And I think we can make a very strong policy statement by putting this mandatory minimum in the law. And I think that taking that out does weaken this bill. And I think it's a very strong statement we can make as a General Assembly about the issues we're having in our communities with gang violence. So I'd urge everyone to also oppose this amendment as well.
All right, we've heard both sides. Let's take a vote on the amendment. Those in favor of the amendment signify by saying aye.
Aye.
Those opposed?
No.
Call for division.
We'll show of hands. Those opposed, raise your hand.
Opposed?
All right, those in favor? All right, the amendment fails. You had a third one, correct?
No, I think
Chairman Coomer, did you have a third?
No, that's all.
Okay. All right. You have before you further discussion? All right. Hold 1 second.
Mr. Chairman, I'm very friendly to the gentleman's strengthening the gang act. I want to kind of put before the committee, I'm contemplating an amendment relative to Section 2, 32 through 55. Yeah, I voted to oppose the Coomer amendment because I do think that the core part of this bill is being able to crack down on using telecommunications devices to run criminal enterprise. I'm concerned with Section 2, what we're doing here without an awful lot of debate, at least in the full committee level. What we're doing is we're having a separate offense that if somebody commits a felony and they seek to conceal the felony, which, you know, I know prosecutors tell me all the time, criminals aren't the smartest people, smartest apples in the basket, but I'm wrestling with, this seems to be a really big change in policy for us as a state, that anybody that commits a felony and seeks to conceal said felony, which you think would be the vast majority of felons, this creates a separate offense that would itself be a felony. That if the felony conviction weren't secured, clearly there was, it was demonstrated with pretty simple findings of fact that the concealment was there. Who knows? This seems to be a policy question outside of the realm of a strengthening of the gang statute. I know perhaps there's value to this specifically with respect to gangs. If this were within the gang part of the code this applied, if this was a signature of gang activity, then it would seem to be consistent. this seems to be a much broader policy question than what I had anticipated coming into the bill. I wanted to share that with the author and you can get us there.
Do you have a motion there?
I'm contemplating a motion to strike section 2, and I wanted to hear the gentleman's thoughts.
In its entirety.
So, section 2, as I read it in its entirety, creates this whole new structure, which is anyone that's convicted, or anyone who commits a felony that seeks to conceal their felony has a second felony, which is the concealment, which is tampering with evidence. I think this is a policy question outside the bounds of the gang statute, but I think we ought to have a discussion around it. Is one gentleman's thought?
Representative Trammell, I think you're wanting to talk on this topic.
Mr. Chairman, I was going to offer the amendment that Representative Setzler is contemplating, so I'll let him contemplate first.
All right.
Yes, this is broader than just the gang. You know, where this applies in the gang act, Mr. Carlson can talk about cases where a drive-by happens and the first thing they do is they paint the car, burn the car, destroy it, whatever. You get the gist. But the way this policy is right now is that if you're driving a car and you commit a drive-by in that car and then you ask your buddy to paint it, that's a felony. But if you do it yourself, it's not. I don't think that's consistent. I don't think that makes sense.
The reason I ask the question is, the reason we have pretty stiff crimes around felonies is because you've got criminal intent, and there's a whole host of, this whole chain of events that comes along with it. There's the formulating the idea, there's the kind of bringing it about, there's the bang, the shot, whatever, drive-by shooting, and there's a whole series of events that follow that. And it seems part of that offense is trying to conceal it, trying to get away, trying to hide the gun, bury the gun, go take out the camera that might have filmed it. Any series of things. And I just think there are certain circumstances. There could be fact patterns where it could be a separate offense, like breaking into a building and knocking out a security camera. That perhaps is a separate thing. But the idea of tampering with evidence to destroy evidence in furtherance of a felony that somebody commits, that just seems to be part and parcel to felony. That's part of the process of felonies and prosecuting felonies.
I think the deviation that they may be concerned about is used in present time. That is part of the circumstances surrounding the facts that go to prove the underlying felony. If you have a person who you found hiding a gun that later is discovered to use to murder someone, you use that as evidence of the person who tried to commit the murder. And I think that's where you're saying that's how we've used those things in the past. But now we're going to use those things not only to prove the underlying case, but also to charge a new felony.
Sure.
Yes.
If I could, I just, as I read through this, and this is not a statute we spend an awful lot of time on, so forgive me if I'm off here. But when I'm reading lines 36 through 39, a person commits the offense of tampering with evidence when, as you read through this, it would seem to be knowingly destroys, alters, conceals, disguises physical evidence, or makes, prepares or plants false evidence. It would seem to be a pretty straightforward set of facts that if you're being charged with a shooting, or charged with a murder, or charged with an aggravated assault, that it would seem to be a pretty straightforward set of facts to prove tampering with evidence. That, hey, this is the gun, we've done a ballistic test, it was the same bullet, the bullet matched the gun, there's fingerprints, there's whatever, this is registered in your name. And it would seem that even if you don't get a conviction on the aggravated assault, that the finding of the stashed evidence would itself be a way to hook in and get somebody for tampering with evidence that doesn't exist and has never existed. It would, it has seemed to be something that was reserved to this co-conspirator, if you will, that's going to get rid of the gun for that. That brings them into the crime, but it would seem to be a pretty simple set of facts that you could generate and get a felony conviction on somebody, where perhaps you couldn't even get conviction on the underlying charge.
Seeing the hour and where we are, I'm fine to leave this to the will of the committee. I mean, if
I just want to make an amendment which I think is ultimately friendly to the passage of good gang statutes that I think is perhaps this could be a separate measure if it stands on its own. I would make a offer amendment to strike section 2, lines 32 through 55, and the bill in its entirety renumber accordingly.
We have a motion before us to strike lines 32 through 55. That's the item.
Any objection to that amendment? Hearing no objection, that section 2 will be stricken. Now we have the full measure of the bill in front of us. We have LC 296932 ERS as amended by the full committee, which includes, just to clarify again, the striking of lines 32 through 55, and on line 90, the striking of the word "for." Any questions on what we're about to vote on? All right. What is the will of the committee? All those in favor of passage of HB 874 as amended? All those in favor, aye?
Aye.
All those opposed? All right. Congratulations.
Thank you. Thank you. Thank you.